Just filed the
Item one.
Is Mr. P.K. Beryl and its counsel appeal the appellant has submitted before us that he has instruction to do this appeal. Start. To the memorandum in that regard has already been filed. And the same is taken on record. We do not find any impediment allowing the appellant to do this appeal. The appeal stands dismissed as withdrawn. Next.
Page number 2, item 6. Page 3, item 7 to 9. Page 4, item 10 and 11. Page 5, item 12. Page 6, item 13 to 15.
May I mention item 15? This is the PIL concerning the elephants. I made a mention on Friday. I directed Dr. Nair, who is the
other counsel?
They are on these teams. They are on these.
Application, Lordship, this matter may kindly be taken up, Lordship. In absence of, suppose Mr. Nair is in
They already reported that this demonstration cannot take place. So,
may be partnered through item number 8. I forgot to mention.
The committee is
item number
8, my lord.
Lordship that ahead of it.
Yes, item number 8 also.
Yes.
Item number 8, the writ appeal 2054, it was directed to be listed. That may come along with that tomorrow, my lord. That Kondodara matter which let's fixed to do today. My father's writ appeal has come. The state government's appeal has not come.
Just to give the number?
Yes. 2054 of 23. Writ appeal.
All right. Item 8. Please this again with WA number such and such. Tomorrow.
Maybe on Thursday.
Thursday. Okay,
Thursday. This bench may not be there. This bench substantially hard this matter.
All right.
Okay, Wednesday. Yes, madam.
Wednesday, yes. Wednesday.
Your Lordship, item number 15, your Lordship, can you take it up, Lordship, in due course? Lordship,
item number 15 will be taken up. We have not passed any order. It will be taken up in due course. Just wait. Yes.
This is a phrase admission matter. Any date convenient to lordships.
Very senior is a stand.
Oh, sorry, I'm sorry.
For some time. Yes.
My lord, 3 matters for restoration of the main application involving an application for forwarding the matter for arbitration. There is arbitration clause. So I pray that
relating to the arbitration petition.
Yeah, this is a petition, my lord, for implementation of the arbitration petition.
But they have been mentioned before the appropriate bench. This is not the bench to go.
This is because it has been dismissed, it has been restored. No case has been restored.
No, this is the arbitration bench. You just make a mention before the deputy registered judicial. You list it. Yes.
I may pardon, with your lordship's permission, one CMAPL. It has been dismissed for default before the then Chief Justice sitting with Justice Chittaranjan Das. I had mentioned before the registered judicial.
Deputy registered judicial.
He said that there is, unless the bench is comprised by your lordship, they will not reach the matter. The bench will be comprised by your lordship.
So I'm asking you to mention the matter before the deputy registered judicial. Who will bring the administrative file to me? This is nothing to do judicially. All right.
This is a writ appeal matter, my lord. Your lordship, all the accept cases fit to 14th, my lord. That is regarding to RS scheme. In between, in the meantime, your lordship pass the judgment, my lord. Upload the judgment. So let it come along with that matter on 14th. Your lordship passed the order on 810/2021. Order as well as the memo. Your lordship
speak of this matter, batch matter.
Asking your lordship's kind indulgence. This is a phrase admission matter. Any date convenient to lordships.
May I pardon to mention, Lord, contempt of the Honorable Single Judge has fixed the matter tomorrow for filing affidavit and for personal appearance on 15th. But this matter arises out of violation of entry murder. That entry murder is not ambiguous order, and that order has not been
Difference before that court, where is the question of appeal before a division bench from a,
it is a contempt appeal.
how can a contempt appeal lie from the civil contempt?
Yes, Lord.
It lies according to High Court rules. Against order passed in a civil contempt appeal lies in the division bench.
Yes, Lord. That is the Lord, section 19 of the Contents of Court Act.
You read section 19. That is why I am telling you.
Yes.
Section doesn't permit this appeal in all matters. You read, and this has been followed for the series of decisions. Unless someone is punished, no appeal lie. Here, no punishment order is there.
For giving punishment, the matter is fixed to 15th.
You are against an order passed by even order has not been passed. You are coming to an appeal. What purpose it will serve? Section 19 is not applicable in these cases. If you want, we can take up the matter even today at 2. There is no difficulty. But
Let's take up on tomorrow.
All right, let it listed tomorrow.
I may be pardoned to make a mention, my lord.
I have filed on Friday, but it has not been numbered. So I will provide the number.
No, collect the number and then make the mention. Otherwise, what is the use of how is such?
My lord, pardon to mention, it is a residual matter, my lord. Since 2008, my lord, the petitioner is prosecuted, my lord, before this honorable court. Order passed, my lord. But
I'm already check up the matter. It is not from 2008 matter, usually is not pending.
2008 dispose of your lordship was directed. But since another writ application is pending, my lord, that for that reason compensation amount was not given.
All right, let us check.
Come to
4021.
All
right, let us check. Just report.
Sir, one appeal that was listed on 4th August, but could not be taken off. That's the date was given to 31st August. But till today, it has not been listed.
There is a review petition, Lordship. The review petition 61 of 2022. My Lord, my Honorable Miss Justice Savitri Vatho was hearing that the notice was issued. The tribunal had actually crossed that order, and then the High Court also confirmed the tribunal's order, disciplinary action order. However, after this notice was issued in the review petition, the pensioning benefits of the petitioner has been held up, Your Lordship. So I pray the Lordship to list this matter.
Whether it comes under our jurisdiction?
Yes, sir. One of the members of the review petition was
mentioned before the registered judicial.
Pardon, Petition number 17780 of 2023. The Lordship has finished this matter on 30th of August. For 10 days, this matter has not been listed.
Let's check up. Give the list. Let's check up this.
I may be pardoned to
check up. If it is not subject matter, inform the council.
Yes. My lord, I may be pardoned to make a mention, my lord. Writ appeal number 1075 of 2023, my lord. OPC is the appellant in this case, my lord, and my lord, the urgency for mentioning, my lord, contempt has already been filed against the order passed on date 19/4/2023.
Witness take up the matter.
My lord, another writ appeal 1349, similar matter.
Your Lordship, another review petition 66 of 2020. It has not been listed yet, Your Lordship. And the order against the Chief Justice, Your Lordship, has been we have filed this review against that order.
It is a last. That is Chief Justice is single bench?
No, division bench.
With whom?
Justice BP Lautrey.
So you mentioned before the registered judicial or deputy registered judicial?
I beg to order, Malad. Malad, in this elephant matter, if this meeting will not held today, Malad, day may be fixed, Malad, for meeting.
Only thing, the demonstration for which we directed by the last order will not place because he's suffering from dengue. He made an application beforehand and we also informed the council, but the matter will be taken up. We have not passed any order. Item 15 will be taken up.
I may be pardoned to make a mention, Your Lordship. One writ appeal number 2226 of 2023, fresh admission regarding.
My Lord, this is fresh admission in this aforesaid case. Petitioner prayed for the inquiry regarding the corruption of Veer Surendra Shah University Technology. Sold the valuably mobile property. My Lord, my best.
Yes.
PL number washing 95. It was on, according to you, last Saturday, special bench, but it was not there.
You're not listed on
Saturday division bench is not there.
Oh, okay. Okay, matter will be taken up on Wednesday. You just repeat the number. Case number, please repeat the case number.
16195.
Saturday division bench was there. 10 matters were listed or something.
16195. I number is 12987.
All right. You have taken note of this number?
16195 of 42.
All right.
Please lesser serial number, sir.
All right. It will be taken on Wednesday. Just wait for 2 days. Yes.
Okay. Thank you, sir.
Let's go over.
Okay, then Mr. Rai's matter.
Yes, okay.
730.
My lords, may it please your lordships. My lords, vexatious and
Just a minute, ma'am. Just a minute.
vexatious and
I am filing affidavit today in respect to our the wrong of dates as well as some factual facts is required to be submitted. I am just supplying the copy of this affidavit is ready, my lord. Lordship, if they come with this nothing more, only strictly statutory provision is there, as well as it is well known to them that what sort of form is required to be submitted to the department. Only that thing I am submitting from my lord. Let them argue, continue the argument.
yes, yes. I will proceed.
That's I am signing the copy just now.
Yes, yes, yes. You will submit at the last moment, I know, to delaying the process.
Our evidence. Let you make also his observation on your delayed
Let
filing.
them continue.
All right.
Yes, let me continue.
Yes.
My lords, in reply to
There is
that frivolous affidavit
there.
which said that
Keep the physical copy of that file. Yes.
that
It is open.
kayo tangko additional affidavit.
Sealed.
Ada tang additional affidavit mo. Para 5 of the affidavit saying that we don't want to. The person died at the time of submission of the form, statutory form 3C, which they have also admitted in their affidavit, which was filed on 22nd of April 2021 and 17 days, sorry,
Yes.
my lords, petitioner has given false information and violated section 12(a)(1) of the FSA Act. Then false affidavit I have given in my rejoinder affidavit, giving the medical certificate under Annex A1 that the vice president of the society died on 29th of April 2021. That is 7 days after the submission of the form. And I have clearly mentioned who are the office bearers, and there is no dispute about that. No dispute. That is, your lordship will find 3C. I have given also who are the office bearers, and that your lordship will find in their additional affidavit at page, I am giving ballots at page 12. At page 12, they have themselves, they have written, Sister Krupapal, whose Aadhaar card has been given, then Mannat Rosie Antony, whose death certificate I have enclosed in my resounded affidavit. Well, how can a person who was alive very much on 22 by an frivolous, false and misleading affidavit say that she has died?
Yes.
Well, I'll just bring to one decision of the Supreme Court, which the Supreme Court has deprecated the practice. Para 28, your lordship will find how the Supreme Court has heavily come. Para 28, my lords. You cannot take the court to a playground.
Para 28.
28, my lords. In so much proceeding against R. Karupan, advocate in, that is 2001 Supreme Court cases 289, the Supreme Court relied on. Then they have quoted that said order. Courts are entrusted with the powers of dispensation and adjudication of justice of the rival claims of the parties, besides determining the criminal liability of the offenders for offences committed against the society. The courts are further expected to justice quickly and impartially and not being biased by any extraneous considerations. Justice dispensation system would be wrecked if statutory restrictions are not imposed upon the litigants who attempt to mislead the court by filing and relying upon false evidence, particularly in cases the adjudication of which is dependent upon the statement of facts. If the result of the proceedings are to be respected, these issues before the courts must be resolved to the extent possible in accordance with the truth. The purity of the proceedings cannot be permitted to be sullied by a party on frivolous, vexatious, or insufficient grounds, or relying upon false evidence inspired by extraneous consideration or revengeful desire to harass, which is in this case, revengeful desire to harass or spite his opponent. Full stop. Sanctity of the affidavits has to be preserved and protected, discouraging the filing of irresponsible statements without any regard to accuracy. Whereas you file just throw an affidavit saying that yes, she died, and I have, by giving false information, I have attempted to take the foreign contribution. Where the rejection itself, which is annexed at Annexure 1, is without any reason and says that your renewal application is rejected. And the Jharkhand High Court imposed a cost of rupees 10 lakhs, my lords, and Supreme Court did not interfere with that because of this false affidavit. There must be some end to it, my lords. First, you file an affidavit saying that there is a siphoning of the funds. Second, again, you claim that there is a conversion of the religion. Then, thirdly, you come up with an affidavit that an office bearer has died.
Yes.
And Absolutely, the medical certificate malus knows that it's a public document. It needs no proof. Now you say that this is not the prescribed form, and you yourself in the artisanal affidavit said that this is the form, and you have applied on 22nd of April 2021. There must be some end to it, my lords. It cannot go on for last 1 year. It is been they didn't file a counter affidavit. Counter affidavit was filed only when the lawsuit took was upon the session of this matter in March, I think, and your lawsuit was categorically directed to produce the field report. Field report was seen by your lawsuits, and your lawsuit directed again to file affidavit within a particular period. They did not file in that period because of some manipulation to be done. And the manipulation came to light when the affidavit was filed, saying that the vice president of this society died on 22nd of April 2021 when the application was filed. No, that's supposed to be, when you are coming to the court, well, there is a re-jurisdiction court, whatever it may be, my lords, you have to, what is the truth? You must come, you may lose or you may win, doesn't matter. But you cannot just sigh away filing some false and frivolous affidavit. Well, it attracts heavy cost. Heavy cost to be imposed on the author of that affidavit who has shown this affidavit.
All right.
That's all, my lords. And this is also, my lords, in violation to fundamental right under Article 21. Life and liberty should not be taken away. And there are 72 children are there. I have given in detail who are autistic, who are falling from cerebral palsy, and also who are mentally retarded. I have given their name, given their numbers. And there are, in my affidavit also I have stated that it requires regular checkup, regular nourishment, and also involving mallards, this medicine, food, everything. As to your whimsical and mercy, you will just deny me. And now you go on making pleas after pleas, all false and frivolous. That's all matters.
Yes. But solicitor.
Yes. May it please, Your Honor.
Yes.
Lord, today's file affidavit. Before that, I am just asserting additional affidavit filed earlier. Lassi may come to the paragraph 7 of our additional affidavit dated 15/5/2023.
Yes.
In paragraph 7, we specifically stated that a field inquiry has been made. It is inadvertently this field inquiry officer has given a, admittedly it is a wrong report, that instead of death of 21, he has written 20. That's why additional affidavit is filed, that whatever report is coming from field inquiry officer, instead of 21 is wrongly written 20. This is not disputed, my lord. Like K-Woods a person is, my lord.
No, just you come to the death certificate was in your possession.
Yes. Then we will make another inquiry. That's how that they are giving certificate to us. He is died on 21st. On field inquiry report, you have written 20. Which one is correct?
21st?
29th.
20. No. He has given a death certificate. After getting the death certificate, we are asked again to the field officer that what is the correct date. They are giving the death certificate. You are giving another date. It is 20 and 21. 20 in the year 2020. In the year 2020, year 2020 was written in our affidavit. Their certificate is 21. So confirming that their certificate is correct, that date is correct, our field inquiry officer has given a wrong report. But simultaneously, same field officer has given a report basing on which we have acted upon.
What steps have you taken against that field agency who has given wrong?
Already office, after getting the same, the concerned officer has taken care of their proceeding in this way.
What way?
I don't know the officer.
Taking care what way? This is a serious matter.
Yes, already it is coming under the Department of External Affairs.
Precisely, this is not the issue before us.
Yes.
Issue before us, this is one of the ground.
My lord.
You have taken two grounds.
My lord.
So there, the non-renewal of certificate is concerned.
Yes.
One of the ground is that they have filed a false statement.
Yes.
And that has been in the name of a person who is already dead.
My lord.
What corrective action you have taken?
My lord.
That have you tendered any apology that we earlier have committed a mistake before this court? Because of these are facts, we did the mistake, you have not filed.
Well, that's why you have today file an affidavit.
There is no apology, anything.
This affidavit also.
One apology is fine. I'm sorry.
Just show this line that where you have tendered apology.
Son, in this affidavit,
it's not that you are not almighty in the court proceeding. Let it be very clear.
Word inadvertent has also not been used.
No, inadvertently it was written. It was written.
Read this relevant paragraph.
Read paragraph 5 aloud. Read it, please. Mr. Badi, please read it. It is submitted that as per the inputs. You read or I'll read?
Yes.
Page 2, paragraph 5. Second para. Please read it. Please read that paragraph.
Yes.
So that it's clear.
Yes.
It is submitted that as per the inputs.
The inputs provided by the field agency regarding death of sister Manat Roshi Antony, Vice President of the death was April 2020, and basing upon the same, the opposite party had filed a counter as well as additional affidavit. But when inquiry was made from the field agency, after receipt of the rejoinder affidavit, specifically with the regard to the death of sister Manat Roshi Antony, Vice President of field agency submitted a report reflecting the date of deaths of sister Manat Roshi such and 29/9/2021.
Yes.
Then at this juncture, it is submitted that the petitioner was knowledge regarding the death of sister such and such as admitted by the petitioner in the rejoinder affidavit. However, despite knowing this fact, the petitioner did not, my lord. Then it is new thing is coming, my lord. Suppose they have submitted, admittedly their 27 application was accepted by us, but it is not legally sustainable because after the death of a key post holder, they have to submit an application under 6C of the statute, my lord. That was annexed in that today's affidavit I annexed.
Mr. If you just travel beyond the date of your consideration,
my lord,
you will be make this consideration very expensive, and this is not under challenge. If you want to take action for non-filing within 15 days, the relevant record of death and substitution, seeking substitution in their constitution for operating the bank account, that you can start a fresh proceeding. But we are only concerned and confined to your decision taken by not granting this renewal of the FCRA certificate.
This field inquiry report was come to us, and paragraph 7 is very clear.
Try to appreciate our position.
My lord.
Now you are bringing a new point.
My lord.
That 17A they have not complied.
Yes.
How the 17A related on the day of your consideration? You did not know.
My lord. It was subsequent event, my lord. Admitted your subsequent event.
So we are concerned on the date cause arose, that when you have taken a decision, what the material you considered, whether the on consideration of those materials, a student person can come to a decision that you have come to.
My lord, I am putting my question to myself also. Suppose the application is coming on 21.
Yes.
And within 7 days, one person is death. Within 15 days of making the statutory provision, they have to submit a 17 application. Yes. They didn't submit. That means the application submitted to the authority concerned is not valid in the eye of law. Suppose they have to declare within, now it is 45 days, then that was 15 days.
We do not know whether they have submitted it or not.
No, they have not submitted. That's why I wrote you. They have not submitted the application, even though accepted it.
This is the affidavit has been filed today in the court.
Yes.
Right?
Yes.
Though the affidavit, it appears, was signed on 8/9/2023.
My lord. Yesterday, they've come and sign it. This concerned undersecretary has come and signed it because
How can
I
it,
asked him to come and
Mr. Badi, how can it be day before yesterday he has signed?
Here's Saturday. Is it Saturday? He was for 3 days here.
I'm very sorry. Please check your dates again.
He's coming.
Your dates are wrong. It is dated 8th Friday, not Saturday.
Friday. They'll come Friday. So Thursday is Friday.
You say Saturday, then Thursday, Friday.
I'm just remembering that. Sorry, madam, but they have personally come and swearing in. I'm not taking because it is difficult on my part also understanding all this factual. They have come with their records because this record is not available here. Because those statutes they are coming, generally it is not in our practice, so it is not possible to get it and submit it to the court. So whatever my submission, my lord, suppose a person is eligible to get any foreign contribution, whatever may be, and as regard to the children's part is concerned, we are very conscious. So that's why I am asking them if the children are suffering.
Concerned, you withdraw the objection. That will be the right way.
But thing is this: in foreign contribution matter, the matters are pending in Supreme Court as regard to different issue.
No, don't make these unnecessary references before this court. If this matter is before the Supreme Court, we understand. This matter
the issue is in Supreme Court.
No.
Taken it before the
Issue that the general issues are there.
Yes, here is the issue only limited on about the head is there. The same this point. Whether anybody is getting the foreign contribution
regarding the compliance after death, regarding the bank accounts,
ballots.
Do you have the instruction whether the bank accounts they have been informed changing the parties in the bank account?
Ballots.
Because 17A of the FRCA
right. That is definitely I will ballots. I am they will definitely I will take the instruction. Now, my lords, the thing is that
please, because we will pass the order, we composite order, not part by part.
Yes.
Take the instruction.
Tomorrow, my lords.
Tomorrow you can do that.
Yes, I can ask.
Tomorrow, part in part. In view of the affidavit filed today by the opposite party in the proceeding, it appears to us that Mr. Ral and Mr. S. Ral and the Senior Counsel appearing to the accommodation to the instruction in respect of compliance of Section 17, capital A of the Foreign Contribution Regulation Act 2010. So we have heard Mr. C.K. Paril and Deputy Solicitor General of India appearing to the opposite party. Mr. Please matter at 2 tomorrow.
But ballots
oh no. This will be taken up at 12:30 tomorrow. 12 tomorrow.
12 o'clock.
12 tomorrow.
Let's me reply on the BS Raiguru.
The court now, this is a new story which they have built. Now
only we want to know whether you have complied this thing.
Yes, we have complied by informing the banks.
Don't presuppose anything.
Okay.
Because it is the requirement.
Yes.
Whether you have done it, not you, just for our information.
Yes, definitely.
File a one-page affidavit.
Yes.
That will do.
Yes.
Only
I'll
on
do
that point.
I'll do that. Oblige. Item number 2.
Judgment also.
No, please, Lordship. The matter relating to the illegal encroachment made the second journal of the petitioner. On the first occasion, Lordship, while the matter was disposed, kindly glance on page 25 of the brief in paragraph 6.
All right, what action they have taken? Tell us.
They have given the obligation to approve the move before the statutory authority. Accordingly, the petition also moved before the statutory authority on 9/5/2022. That is by Annex 10 only by 26. Till that the OP number 3 has not taken any action with regard to the representation of the petitioner.
Mr. Mohanty, what is happening? People coming in your rescue, you are not even then responding.
His allegation is that there is a representation pending, but there is no, my lord, there is no acknowledgement of receipt of this page 26 Annex 10. There is no acknowledgement of receipt of this representation. Lordship direct.
Do you have any acknowledgement now? It is also not.
No, neither it is sent in by post or email.
No, all right. We'll ask him also file a copy of the representation through you also. You can send the representation.
Yes. So Lordship direct that he will submit a fresh representation and that will be considered.
That is better.
That is better, my lords.
Heard Mr. S.K. Mohanty, when counsel is hearing for the petitioner. Stop. This is the second round of public interest litigation on the same issue. Straight has asked this court to direct the opposite parties, particularly the Tahsildar, Attabira, to pass the speaking orders on Annex 4, speaking order on the newspaper report dated 13/12/2015, Annex 4, to the petition.
Since 2022,
Mr. Mohanty,
yes,
counsel for the petitioner has referred to the order of this court, order dated 11/4/2022, passed in the earlier public interest litigation, earliest litigation, being WP number 6079 of 2022, whereas the judge of this court had directed the opposite party number 4. Opposite party number 4 was the Tahsildar.
Tahsildar
is the 3 worship.
No, just the earlier order.
Earlier worship.
The
earlier order,
opposite party number 3 to take appropriate action against the encroachment of the public road by the opposite party number 7 of this petition. So, all right. All right. Just read the last part. No, directed the petitioners, the square to approach the statutory authority under the relevant provisions of the statute. According to Mr. Mohanty and counsel for the petitioner, he has filed a representation. It is filed to the
Tahsildar.
Tahsildar, number 3 years.
Filed to the Tahsildar
on 9th May 2022.
On 9th May, Tahsildar Attabira
on 9th May 2023. 22. Stop. Even after a flux of 1 year, according to the petitioner, no action has been taken on the said representation. At the outset, Mr. D.K. Mohanty, National Government Advocate, appearing for the opposite parties, has submitted, state opposite parties has submitted that from the said representation, it cannot be gathered whether the said representation was really received by the statutory authority, i.e. the Tahsildar Attabira, or not. So, having situated thus, we direct the petitioner to file a fresh representation to the Tahsildar such and such within a period of 15 days from today. Stop. On receipt of the said representation, the Tahsildar shall make the appropriate inquiry in respect of the encroachment of the public road by the opposite party number 7, and on inquiry it is found that the public road has been encroached by the opposite party number 7. After affording opposite party number 7 an opportunity of hearing, appropriate steps should be taken. He's also 7 here?
Yes. Oh, 5, 6, there are 2 other respondents.
Is that the other private opposite party? 5, 6, 7.
Oh, who is in encroachment?
OP number 7.
Only.
Oh, all right. OP number 7. The step to evict the OP number 7 from the public road. The entire exercise, including the inquiry, shall be completed within a period of 10 weeks from the date of receipt of the application, the representation. In terms of the above, this petition stands disposed of. A copy of this order be supplied to Mr. Mohanty, an National Government Advocate, for onward transfer.
My lord, he will submit this order along with his representation.
Your prayer is to take action in, on basis of Annexure 4, newspaper cutting.
Is also I was.
First, the newspaper cutting, this representation, and exchange. You should be careful when filing the application. Yes. All right.
All right. Item number 3.
Please, my lords. My lord, there is a illegal encroachment over the government land, my lord. As a result, we are suffering a lot. Our only way of communication has been blocked, my lord. That's why in this regard, I have also represented to the government, my lord, the collector Mayurbhanj, and that representation is pending before him, my lord. That is Annexure 3, my lord.
Same order.
Same order.
And I have also filed
here. Mr. P. Behera.
My lord.
Mr. P. Behera, the counsel appearing for the petitioner. By means of this public interest litigation, petitioner has asked this court to direct the Tahsildar Shamakhunta, Shamakhunta, the opposite party number 4, and the executive officer, Baripara Municipality, the opposite party number 5, to take immediate actions to remove the illegal construction and fence from the government land. Stop. Mr. Behera Land Council has submitted that the petitioner has filed a representation on 18th of October 2022 to the collector Mayurbhanj, in bracket Annexure 3, and thereafter he had filed. No, this is the photographs. 4 is the stuff. But no action has been taken on the said representation. Stop.
Lordship may direct him to file a representation before the Tahsildar.
That is why, in our considered view, the representation is filed with the petitioner after being filed before the Tahsildar.
A copy has been supplied to me.
Tahsildar Shamakhunta. Stop. It appears from the representation dated 18/10/2022, a copy of the said representation also forwarded to the said Tahsildar by registered post. Be that as it may, unless a representation is addressed to the concerned authority, he cannot take any decision on the said representation. And we are also not aware whether the collector, Mayurbhanj, Orissa, to whom the representation dated 18th October 2022 was made, had reverted that representation for consideration by the Tahsildar. So in such circumstances, we direct the petitioner to file a fresh representation to the Tahsildar with the statutory authority for purpose of evicting the encroachers from the government land for taking due action. Such representation shall be filed within 15 days from today with all documents, if any, stuff. On receipt of such representation, Tahsildar shall take appropriate action after due inquiry and affording opportunities to the person who is, if any, encroaching the government land. Stop. Such exercise, including the inquiry, shall be completed within 10 weeks from the date of receipt of the said representation. So petitioner is directed to submit a copy of this order with his representation. So that apart, we direct the registry to supply a free copy of this order to Mr. D.K. Mohanty, an additional government advocate who has represented the opposite party, state opposite parties.
My lord may make it 30 days. Your lordship may make it 30 days because he will make an inquiry and pass necessary. 10 weeks. I'm sorry. I'm extremely sorry.
You thought it's 10 days?
Yes, my lord. My lord, he maybe serve a copy to me. No copy has been served.
Item 4.
Next.
Make page, your lordship.
Copy of this petition is served in the proceeding. This is the defect stands.
Yes, I have received.
Yes. Item 4. May it be. My lord, this is a writ appeal. Writ appeal challenging the impugned order at Annexure 5, page 190. What was before the Honorable Single Judge was the applicability.
But there are some defects on the council. You have not deposited the 50. Have you removed all these defects?
I think I have removed everything.
In just a minute, let me check it.
My lord.
There is no note. Not removed. We are listing it tomorrow. In the course of this is simply 50 rupees payment and one copy it has to be supplied.
This copy I have served on the caveator.
3 defects.
Copy I have already supplied.
Office note is not.
And most importantly, there's several pages they have mentioned are not legible. The page number 158, 160, 162, 166. Or day after tomorrow we fix the matter.
It's all very legible, my lord. It's my. I think when scanning there is a difficulty.
No, they ask for the neat copy means it's not legible. It should be readable copy.
It are readable, my lords. We scan while scanning. Maybe they have
these are the seed of.
I'll check up. Can you
see also the black pages there is appearing on the page? Some part is completely darkened.
I'll substitute those. There is no difficulty.
That is why I'm fixing this on Wednesday.
Yes, ma'am.
In the meanwhile, you take the steps, huh? Please the matter in witness tonight. In the meanwhile, the defects is identified, the registry shall be removed.
I will remove.
Heard Mr. Avijit Paul, the counsel is appeared for the appellant, and Mr. D.K. Mohanty or you?
No, that's a private respondent.
Only private respondent. All right. Caveator is there. That
Yes, he's there. Yellow, sir, I'm for the caveator, yellow, sir.
What is your name, sir?
Sohan Misra. My senior.
Sohan Misra and counsel appears for the caveator.
Yellow, sir, my senior is there.
All right. You supplied the copy?
Yes, yes, just not with this.
Maybe subject to me less.
You take that. You have supplied the copy of the go on Mr. Such and as such. And the caveat is discharged. That is separate in order for the caveat. All right.
Let's say appearance memo of Sri Lanka in Senate Council.
Appearance memo. Such and such is taken on the court.
Yes. Item number 5.
Item number 5, your lordships, the first item, 19394 of 2023.
Yes.
In that matter, your lordships, we seek to file an intervention application. This is a property, your lordships, which is a private burial ground, and it has the tomb of Achyutananda Goswami also. And my own father, who's a descendant of Achyutananda Goswami, has also been buried just last year, few months back. So I do, and I am also the owner of this entire property. So in that capacity, your lordships will like to file an intervention application. I know your lordships does not like this gesture. We'll file it in the record. We'll serve copies to all of them. And
that will be taken up tomorrow. You file in the meanwhile so that they can also go through what is there in the application.
Maybe Wednesday, your lordships. I think it will take some time for your lordship to come off your lordship's record.
In my humble opinion, take very small little time for your lordship too, because there are primary issues of maintainability. The lordship is convinced there. I don't think it will take much time for that. Maybe tomorrow.
And there is a significant development in the meantime. My learned friend knows this 41 application which was being adjudicated by the additional commissioner, that is disposed of by a comprehensive judgment, and it is declared that is a public.
Unfortunately, we have applied for a certified copy. We have not been given a copy.
Yes.
But this is an appealable order.
That's right.
And we have certified
groups. That it is our property, it is their property, but in the meanwhile, the property or the PIL has been filed by somebody. There is a complete lack of locus, your lordships. That petition should go. In fact,
we've gone through this order.
You know, that's what I'm saying. We have applied for a certified copy. We did not get it, but they got it. That's the problem.
It's a crime to get
Witnessed.
Lordships.
I would request Mr. Roth and Senior Counsel to supply a copy to have free of cost.
We'll do that.
Well, we have applied for the certified copy since 4th of
All right. You just take the copy.
Well, unless we get that copy shall order, we can't go for appeal, my lord. That is the supplied by Mr. Roth. Free of,
but for this purpose of this litigation, this copy will be supplied by Mr.
But I'll expect a copy from my learned friend.
Definitely.
I'm filing intervention application on behalf of the Pujakas. All the priest do
whatever application you want to file by tomorrow.
Yes,
we are fixing the matter on Wednesday.
Right. In the meantime, my colleague will shop the copy.
So you get 3 cups of coffee.
Yes. 3 cups.
Yes.
Mr. Pai.
Yes. It has been pointed out by Mr. P.K. Raghuvan, Senior Counsel. You are appealing for whom?
The trust board. Trust board.
Trust board in the connected petition.
The collected matter. That's the contesting matter. PIL is not very significant before my lords, but she may take up the other matter which they are.
The state's anxiety is to develop that
That's precisely why did the state endeavor to enter into a private property? That anxiety itself calls for a lot of anxiety.
Is a private lot of bodies are also
Achudananda Goswami and Raghunath Gio Bijay, represented through the managing trustee, has stated that the application under section 41 of the, it was under section Endowment Act, Odisha Hindu Endowment Act, has been disclosed by the order dated. Just see the order date.
That is dated when I wrote 31st August. 31st of August 2020. Right.
Hindu, by the order dated 31st August 2023. So at these junctures, MSP Roth Learned Senior Counsel, who is contemplating to file an intervention application, has stated that they could not collect the certified copy of the said order, and hence they are totally unaware of the content in the said order. So, in view of that, we have requested Mr. P. Roth Learned Senior Counsel to arrange supply of photocopies of the said order to the London Council appearing for the parties in the death of petition. So when the matter will be listed as witness in the date, so it is made absolutely clear those who like to file the intervention application shall file within 12 p.m. tomorrow.
Yes.
So is to directed to compile all these such applications
day after tomorrow
before the next date.
Right.
What is
Day after tomorrow.
It will be listed day after tomorrow, but filing must be complete within 12 p.m. tomorrow.
Yes.
Day after tomorrow at 10:30, or because it will not reach.
All right. Please combine order. Or you give the name to the appropriates. Well, you are there already appearing. File the memo of appearance again.
No. This is my first time I'm appearing.
You just threw this same name. File the memo of appearance.
She should.
Could I be? Just now, my learned friends are serving copies. My learned friend accepted.
So you got a copy. If one certified copy has been given, definitely they have started giving the certified copies. You just inform.
No, we have already made application for that.
Yes, it's not given to us. That's what is saying. So that we cannot go and appeal. Otherwise, we would have been able to go and appeal and got a stay order. That's the whole conscious effort that we did not receive.
All right. That copy period would be excluded from limitation.
The period of limitation, but not.
No.
I mean, we are handicapped otherwise.
Let's see.
Otherwise handicapped.
Item number 6.
But in the connected petition, the interim order is there. Your Lordship may explain that.
Interim order. The interim order.
431.
Second petition. Yes, it will continue. All right.
Item 6.
In item 6,
order last
I have filed a counsel on.
But it is not on record.
On 10th of September by e-filing. I can provide that hard copy.
Means yesterday, Sunday. Good.
Can I give that hard copy?
Have to.
Yes.
Sunday, it cannot come here on Monday.
Just now, just 1 minute before.
So we fix it that day.
You also call it any other next week because the students they are not actually getting the food minutes for.
Next week of 5th of October. 5th of October.
No, you see, actually practical case is they are not getting the food for lots on only 2 days after. You see what lots only after 2 days.
This is a statement.
You see director
providing food. We have released everything, my lord. And what has happened? Well, 3 cases have been filed by the management. One, they have challenged their suspension. Second, when we release their salary cost in respect of the teachers, they also filed a petition not to release. And third, my lords, with the same
You just check up the matter, come on 5th of October. They say the food is supplied.
Yes, we have supplied. We will record this minutes. I don't know. Only on the ground of food I am here. Yes, 300 students are not getting. We have not subsidized the subsidized rice on 7th. Subsidized rice.
7th?
7th of the September. That when
What is doing for all these months? They were serving.
No. We have released all the funds in respect of that management.
The counter affidavit has been filed.
You will see my counter, everything we have clarified.
All right. On behalf of the opposite parties, number 1, 2, 3, and 4, through Mr. M.K. Kuntial and the Additional Government Advocate, the counter affidavit is taken on record. Stop. It has been stated by Mr. Kuntial that supply of food has commenced from 7th September. 7th September 2023. Mr. D.K. Mahapatra, our counsel who appears for the petitioner, has submitted that he has no instruction in this regard, and as such, he requires instruction about the state statement, be that as email, if the matter be listed on 5th October 2020.
Let's call it 25th.
25th. 25th. It has been there, 25th October 2023.
Connected matters.
The food supply and
there are some connected matters.
yes, madam, that I am saying, madam. Because one case that all these matters can be settled, madam. If one case is disposed of, your lordship can call this matter along with WPC number.
So is this matter along with
that I am saying. I am submitting.
17180
Yes, madam. Yes, madam. That there is a stage granted that for that reason that dispute is there.
This is
WPC number, my lord. 17180 of 2023.
Just this is the one.
Three cases are there. My lord, why I am submitting one case? Because that suspension of that management has been stayed in this case.
Okay.
And so if this will be decided, my lord, everything will be settled, my lord.
This number. Yes.
21202 2023.
Yes, three cases are there.
Give.
Yes, I am giving. But first case is 17180 of 2023. Then my lord, next case is WPC number 10153 of 2023. And another is 27841 of 2023.
Another one.
Another one with 21202 of 2000 that has been withdrawn.
Okay. Withdrawn.
Okay.
And for reference, it can be brought for reference because in that
No, because if you want, we'll get
yes, 21202 of 2023.
Now, if it is withdrawn, why should
I am saying, my lord, my lord.
Withdrawn means it's over.
I must have suspended the operation of the order for the
Withdrawn matter is kind of. We are not listing the withdrawn matter because it means.
I am submitting matter because in that case, that the prayer which is made in this PIL, that was the prayer in that petition.
All right, if it is found, we just dispose of it.
One order has been passed in another case. That is why it was withdrawn.
It's all right. My lord, whatever order is not. Yes. On the next matter.
Item number 7.
May your lordship, on the last occasion I have argued it is that brand, your lordship. Cattle feed, your lordship. So bran is taxable during the relevant period. As your lordship, only your lordship has adjourned the matter. That when my Lord Senior stated that submitted that it can be interpreted. So my respectful submissions is the entry was clear for the input period, and the entry.
What you argued on the last?
Your lordship, only that is the case. Your lordship may look into the last date's order. Only for limited purpose, your lordship adjourn the matter.
Yes.
Because at page 8 already entry, I have page 7 entry I have narrated. And also this honorable court in that case, your lordship, Gita Sri. Your lordship, this honorable court has stated that bran procured churni itself cannot be treated as a cattle feed, your lordship, even though it has been sold as cattle feed. Your lordship, for that reason, it is taxable.
Yes. It is obvious already.
Your Lordship.
Yes, my lords. Last occasion, Lordship has directed me to make a submission with regard to whether the doctrine of adjustum generis will apply in tax to the taxing statute, Lordship. In so far as the very doctrine is concerned, the nocita associated adjustum generis, Lordship, it envisages that certain specific words, when followed by a general word, the general word will take its color from the specific words. Here, this facts that is occurs in this case, Lordship, in undisputedly, I am a flour miller, and wheat bran is one of the byproducts that is generated out of milling of the wheat. And the dispute in this particular case is with regard to whether the wheat bran that I sell would come within the ambit of the exemption or not.
Yes.
Up to 1st of February, up to 8th of February 1999, Lordship, I had been enjoying the exemption. And from 1/4/2001 also, I am enjoying the exemption. There are two important dates, Lordship, you might note. Up to 8th of February 1999, I was enjoying it. And post 1/4/99 also, 2001 also, I am enjoying the exemption. What started the dispute is, on the notification was brought by the state government, where Lordship, very meticulously, the petitioner has extracted the various entries in the taxation schedule, Lordship.
Yes.
There are 3 schedules to Orissa Sales Tax Act, Lordship. Schedule A, B, and C. Schedule A is a list of tax-free goods.
Yes.
Schedule B contains the tax goods on which tax on purchase turnover will be levied, and Schedule C is contains the list of goods on which tax on the turnover of sale will be levied. So, entry 30B, the parent entry that occurred, that is the under list A, Lordship, which says that sale of feed and fodder such as horse, straw, hay, grass, oil cake, and manufactured mixed or balanced feed, and for cattle, poultry, and pig. This oil cake was later on was also this by notification. De-oil cake was also added to this. So this entry all the while remained in the statute book, which was not removed. And this honorable court, on different occasions, interpreting this 30D, has come to hold that this is a exemption in general. This is not an exemption, conditional exemption. In different circumstances, this honorable court has held that 30D is an exemption in general, and the 30D is only enumerative and illustrative and not exhaustive. And the honorable court, what the honorable court has said, that sale of feed and fodder, that is what is exempt, not what the subsequent words that follow them. They will not be limited by that. Anything that what the Honorable High Court has said, that anything that constitutes a feed and fodder for animal would be exempt generally under 30D, Lordship. Then the state has also extracted in page 6, Lordship, the other entry that coexisted at the same time with regard to bran. That was a conditional entry. In page 6 of the revision application, the state has quoted it. Bran, the condition was if sold as cattle feed. This very entry presupposes that bran, which I am dealing with, is a cattle feed. Otherwise, this would be meaningless. So I am not here to prove that wheat bran is a cattle feed, or for that matter, animal feed. So my the honorable courts
now what is remains for examination here is whether between the 9th of February 1999 and up to 31st March 2001, when this, if sold as cattle feed was removed from the taxing entry, taxing schedule C, I can be subjected to tax or not. My humble submission is, since this Honorable Court has already said that 30D is exemption in general, and 30D is enumerative and illustrative, and we take into fold all that is fed to animal. Since I am dealing with feed brand, I never needed to be considered under any other provision. I only come within 30D. That was enough for me to come within 30D to get exempted. And another aspect the state has want to bring up in its revision petition, which in Gitasri that he relies on, is completely distinguishable, as I had submitted last time. The Honorable High Court has taken note of this fact that 30D is exemption provision lawsuits. And it is meant for beneficial benefit to the farmers. The state has, in its revision petition, says that I am a flour miller, I am not a farmer. But they probably forgot that Orissa sales tax is an indirect tax. Unlike income tax lawsuit, if I earn certain amount of income, the tax is levied and I pay it out of my pocket. The Orissa sales tax is an indirect levy, and the person on whom the incidence lies under Section 4 lawsuit, he is merely to collect it from lawsuit. That is very basic thing, lawsuit elementary. So I'm not going to that.
Only one submission, your lordship. That entry 30D is not at all applicable. Why, your lordship? The intention of legislature is very clear, your lordship. Just imagine, if this good brand is exempted under entry 30D, then what is the necessity to give another taxable entry and a conditional taxable entry? Your lordship, what my learned senior's argument is that it is exempted, general exemption under 30D, under entry 30D. Then here, brand, if sold as cattle feed,
yes.
If not sold as cattle feed, taxable.
How is the taxing authority to determine that? Whether that barn which is generally exempted.
The tribunal is the final fact-finding authority.
Already.
The tribunal has found as a fact that I have sold cattle feed.
Already. That is a yes.
So by looking into different aspects, your lordship, by tender, by sale this memo, by different sale purpose, your lordship, everything can be ascertained from the tax invoice. Now, your lordship, my respectful submission before your lordship, for the particular input period, your lordship, is taxable, because that except when sold as cattle feed has been deleted. So since the entry is very clear at page 7, your lordship, at page 7 of the writ petition, the entry that brand except when sold as cattle feed, the except when sold as cattle feed has been withdrawn with effect from 8 February 1999. Section 6.
Have you submitted any list of dates?
Your lordship, at page 6 and 7, if your lordship, page 6 and 7, the entry, both the entries have been given and with the date.
No, date chart है ये.
3 dates. With the date, your lordship, it has been given the table. Page 6 entry.
No, that we have read.
Your lordship.
When Mr. Sahu was pointing out, you have taken note of this.
Your lordship.
Just I have to give the dates of your operation which is under this dispute.
Your lordship, but the period
9th of February 99.
Period is 99-2000. 1/4/99 to 31st March 2000, the period.
1/4.
1999 to 31st March 2000. This is the input period, and the notification is at page 7, the second column, the right-hand side column. With effect from 9 to 99, the entry 15, brand, this has been excluded, 4%. So 15 prior to 8 to 99, brand except when sold as cattle feed, 4%. Your Lordship, got it at page 7, Your Lordship. At the right-hand side, brand, direct brand, that has been deleted, 4%. So this is with effect from 9 to 99. My period is 1/4/99. So after this amendment, after this deletion.
Yes.
So my respectful submission, when for the input period, the entry is very clear and the entry is taxable, and the goods which has been sold by the petitioner admittedly falls under that entry, which is taxable at the rate of 4%. There cannot be any other interpretation, Your Lordship. And so far as the 30D entry, 30D is itself not applicable, even though it is general exemption. Why, Your Lordship? Because at the same time, entry 30D was there and entry 15 is there, a conditional entry is there. If at all it falls with the entry 30D, then entry 15, there is no necessity of insertion of that entry 15. Your Lordship, for that reason, and more so, Your Lordship, in addition to that, in Gitasi judgment, this Honorable Court has categorically held that Your Lordship, there are 16 ingredients are to be mixed up to satisfy as cattle feed, and brand, since brand is one of the ingredient, it cannot itself, in that case, chunni and choker, here it is brand. Brand itself cannot be termed as cattle feed and to come under the purview of exemption, Your Lordship. And Your Lordship, tribunal has, in common parallels, tribunal has decided, Your Lordship, I have already placed the tribunal's order. Tribunal only on common parallels has stated that since brand has been sold, in general parallels, brand has been sold as cattle feed, so cattle feed is exempted. So it is coming under the purview of entry 30D. So which is...
how do you can contend generally the barn is not a cattle feed?
I'm submitting that.
On the contrary, that you have to just come to an inference in view of all entry. Barn is a cattle field, but it may have a different use.
Yeah.
That at best you can consider that inference.
It has different use. It was taxable.
That my question is not
that is why I am
how I am selling the brand.
Right. Your Lordship.
And I am saying that is the person who purchased it.
Yes,
the purchase is for the cattle field.
Your Lordship.
I do not know what is the purpose of purchase. I have sold it out.
Your Lordship.
How in such circumstances it is be accessible to tax to
Your
the
Lordship.
seller.
Your Lordship.
Forget about on account of
these evidences. The evidences have to be produced. What happened? One example I am giving.
How we can the evidence? Just tell me.
That also that aspect itself. This exemption continued as I was submitting before my lords. That act also. There's a similar entry which exempted brand. That exemption entry itself mentioned brand. And this Honorable Court in the month of March, the person was denied the benefit of the exemption on the ground that it has been sold to National Aluminium Company, NALCO. This Honorable Court said that the purpose for which it has been sold would not be material. Even in that case also, knowing...
Do you have the recurrence of that case?
Yes, Lordship. I have a copy of that. Unfortunately, I just have a single copy, Lordship. Kamodhanu Cattle and Poultry Feed, Sales Tax Division number 33 of 2014.
Sorry, this Gitasi. Recognizing this Gitasi
is also there. I have, and I can I've distinguished it clearly, Lordship. It is with regard to Section 26 of the Entry Tax Act, which envisages an entry, imposition of entry tax, the liability on a manufacturer.
Yes.
Lordship. So the question there before the Honorable Court was whether this is an industrial, this can be termed as a output of an industry. The Honorable Court, while discussing this made a observation, passing observation that brand itself cannot be paid. But the contrary has also been held in different cases that, in fact, it's also a technical papers are there. Brand, particularly wheat brand, are ordinarily fed. I had last occasion filed National Dairy Development's Board's document that says that on basal level, bran, which is which one of the things that are directly fed by the farmers to the domestic animals in their farms. So it is not a dispute. So in that case, Gitasri's observation is totally inapplicable in my humble submission, Lordship. And particularly Kamal in this case went a step further, where the Honorable Court said that irrespective of the use also, if there is a entry for exemption, then it will be exempted unless it is specifically omitted or excluded by legislation.
Yes.
So in this case, Lordship, what the state would, if the state did not wish to extend the exemption to the farmers with regard to the sale of wheat bran, Lordship, then they could have made a condition, like in the NT 30D itself, exclude certain things from its purview. And it says that excluding so and so, so and so, so and so. Bran is not put there. Had it been the intention of the legislature,
this cannot be a very strong ground for you, because when specific provision is created.
And the second leg of my argument was the subsequent legislation. What happened post 1/4/2001? Just bran, state wanted to impose levy on bran from this 9th of February 1999 to 31st March 2001. And thereafter it became all right for them to exempt it. So it cannot be so. So from 1/4/2001, the entry that has been extracted in the revision application itself, SR 150 and 151 came up. There, the argument was it was a levy on purchase. It hardly matters if it is a levy on the turnover of purchase or turnover of sale, because ultimately it percolates to the person who consumes it. If it is a levy on turnover purchase, it excludes the turnover tax on turnover sale. So the person who first buys it, the registered person, he pays tax on it. Thereafter, it merges with his price, the value of the goods, and it passes on until it reaches the ultimate consumer, who is a farmer. Yes. So in the difference, there is hardly any difference it makes so far as the passing of the benefit to the fortunate
things. I think that's a simple question.
So the other part of the was interpreting 30D. Originally, the quoted the provision was quoted does not include de-oiled cake. What happened in one of the judgments? May I pass on a few compilation of decisions that I have made for you, Lordship, and a note in the form of a bullet points, Lordship, you can say, with regard to the very aspects of this involved in this case. In the compilation of the judgments that I have passed on, Lordship, there was a case in Lakshmi Agency versus State of Orissa. There, Lordship, what had happened, from 30th March 1991, from 1/4/1991, there was an amended brought in the NT30D, Lordship, which say that oil cake includes the oil cake. So after this amendment came in, the assessing officers the assessing officer started reopening the assessment of the dealers and imposing levy on the sale of pea oil cake, which they were originally exempting, taking it as a part and parcel of oil cake, Lordship. So this Honorable Court examined this aspect and came to a conclusion that oil cake, the NT30D, Lordship, NT30D is enumerative and illustrative, and the very word such as, the phrase such as in 30D indicates that the item intended, item mentioned were illustrative and not exhaustive. So, when looking at the amended provision, Lordship, the Honorable Court came to hold that it can be looked from another angle, that this amendment was in the nature of a clarification, and that is why it wanted to clarify the position that a bee oil cake was always intended to be excluded under 30D, Lordship, exempted under 30D. So far as the wheat brand, Lordship, particularly wheat, this exemption, the Supreme Court has examined this in Ramchandra Asaram's case that I supplied to Lordship, Commissioner of Sales Tax versus Ramchandra Asaram. In that case, the commodity which had been sold by the person was broken, damaged wheat. That in that case, Honorable Supreme Court examined a very similar entry in Uttar Pradesh statute and came to hold that Supreme Court said what is exempted under the notification of 5th of June 85, it's cattle fodder. In generic sense, the expression cattle fodder is inclusive of everything that is fed to cattle, including damaged wheat. So they said that the sale of damaged wheat will come within the ambit of the exemption notification, which is very similar to our notification, 30D, Lordship. So the brand, so far as wheat, the 30D is concerned, the wheat brand, particularly which I am dealing with, was all, by humble submission, is always there, which is more elaborately, I mean, more clarified from SR 150 and 151, which went on to impose levy on rice bran only. And another aspect, Lordship, you know that the 3-page copy that of those two notifications I have submitted, after 150 and 151, Lordship, the entry was further amended, Lordship, in 2000, Lordship, 2002, Lordship, by SRO number 19 of 2002. In 19 of 2002, the entry that was rice bran appearing in column 2 of entry 15A, the words except when sold by a registered dealer other than rice bran declared tax-free under section 6 of the Act was added, Lordship. The legislature did not even want to tax rice bran entirely. They put a condition there. The purchase tax was also subject to condition.
Because this is a notification posterior to the...
And this Honorable Court has, in the judgment that I just read out, it went on to hold that this posterior, this subsequent amendments is in the nature of explanation. And whether this can be done or not, Lordship, in several Supreme Court judgments, Lordship, in Manikam and
wait from the subsequent amendments or subsequent statute. Can we take?
Subsequent, yes, Lordship, it has been loosely in Manikam and companies case in Supreme Court, Lordship.
The loosely used was the tax statute as on the date of
the tax statute. In one of the other judgments that I have enclosed, Lordship, in Manikam and Company, it's page 18 of running that I have numbered the pages. Manikam and Company versus State of Tamil Nadu. their lordship, the Honorable Supreme Court was dealing with the section 15 of the Central Sales Tax Act. What is there is, if a goods is subject to tax within the state, then on sale of it in interstate sale, the person, either the tax paid in the interstate sale is not involved in this matter. No, not interstate. For other occasion, this may be a good judgment. Yes, Mr. Mishra, I have only question. Regarding the burden, I am claiming that I have sold to a person and for purpose of the cattle feed. How can you just tax me?
Your Lordship, on the production, because it is a sales tax.
The burden is lies with whom then?
Like you ask the dealer to prove that it has been sold, otherwise then it has been sold as a cattle feed. Because Your Lordship, what happened?
Yes.
In some cases it has been
how to prove this thing?
Your Lordship, sale memo, sale register.
Sale memo is using to the person who is purchasing it.
Your Lordship, his sale register is there. And sale memo, invoice copy.
For this purpose is relevant.
Invoice copy. One example
is relevant. Tell me how this can be treated as the evidence.
Your Lordship, because he has to prepare the accounts.
Little bit of absurdity in that.
Your Lordship, why?
I'm telling you why.
I can.
So I'm purchasing an invoice, a particular product.
Your Lordship.
Forget about the brand.
Your Lordship.
You come across in the daily parlance of our life someone with it is used for the detergent. It is
Your Lordship.
Not rare because this is the level itself of the product is taken into consideration.
Your Lordship,
in problem that you have created.
I can understand. Your Lordship.
You have created without the proper process. How to determine?
For that reason, that except so.
No, you cannot. You cannot shift the burden over on the seller. That you cannot. So therefore, the benefit will go to the seller.
No,
not to you.
Your Lordship, it is a prior period. What Your Lordship?
I understand. I'm taking the law as it was during the time of this 1/4/1999 to 1/3/2020. I'm not looking into the subsequent change in the statute.
Your Lordship, because the petitioner is to keep the books of accounts, the purchase as well as sale. Your Lordship, and the sale details, Your Lordship, he has to prove, since it is an exemption, Your Lordship, conditional exemption. So the onus is always on the dealer to prove that it has been sold as cattle feed.
He has sold it cattle feed by implication also if it is descriptively not written in the register. When he's not charging the tax.
No, Your Lordship, I can look into. Your Lordship,
that is the observation of the tribunal also.
Yes, Lordship. Your Lordship, the tribunal has said that in general principle. Tribunal has not said that. Your Lordship,
come to the order. Annexure 3, I think the order you have challenged.
Your Lordship. Since for the improved period, Your Lordship, brand became taxable and that condition has been withdrawn. For that reason, it has not been verified whether it has been sold to any farmer, any agent. Because previously, Your Lordship, in NALCO case, in so-and-so case, all tenders have been verified. Your Lordship, since during this year, that has been deleted, this verification has not been done by the assessing officer. What I think.
You will come to the page 31. Page 4 of the internal page 4 of the order that you have in any case of the matter. The specific case of the appellant. After that, the observation.
Your Lordship, in the first line, the assessing officer, without specifying any reason, simply included the turnover of sales of wheat farm is the taxable turnover determined by him. Why he has not verified that whether it has been sold to as a cattle feed or not, because during the particular period, the entry was very clear and condition has been deleted. For that reason, there is no scope. There is no why the assessing officer will verify that whether it has been sold to any for the purpose of cattle feed or not when the entry is clear.
That is why the tribunal examined themselves.
The tribunal is not examining the principle. No, I need to look into the observation of the tribunal. You know, see, in the first appeal, the appellate authority deleted the addition on account of non-furnishing of form on submission of form. However, he appealed the inclusion of turnover of wheat bran in the TTO on the ground if sold for use as catfeed having been deleted from entry 15 in the taxable schedule by notification number so and so wheat bran is exigible tax for the relevant period. The specific case of the appellant, he effects sale of wheat bran husk, which is essentially known in common parallels. And common commercial parlance as cattle feed, and as such the same is exempt under 30D of listed. In support of his claim that wheat bran is essentially cattle feed, only judgment, only interpretation, your lordship, no details that it has been sold as cattle feed, no details have been submitted. Why, your lordship? Because during the year, the entry is very clear, the condition has been withdrawn. If condition was there, the assessing officer has to verify the details from the books of accounts, whether it has been sold as
under the exemption or not. That is all right.
Since entry is clear, nobody has verified. Because assessing officer first appeal, nobody has verified, your lordship. All the orders are categorical.
That is why I am asking you. Suppose the dealer wants to verify the person who is purchasing it.
Your lordship.
Do the statute give him the authority to ask for the documents, details, what you are doing about it?
It was in fact, if lawsuit called for the records before the assessing officer as well the first appellate authority and as well in the tribunal, these documents are there. It is there. The tribunal has noticed my sales register and the memos. So and so Gokhadya Bhandar and all that. I think probably I would have it in my record also, some of the invoices.
Where the observations you come, that observation?
The observation page 6 does in any case of the matter, the tribunal says
that there is a measure saying that there is no detailed discussion. How the
better have been discussed there. In the brief notes of submission that I have filed with the tribunal, I categorically mentioned it and filed those documents before the tribunal for for copies of the documents, because they were already there before in the court's records.
Your lordship, more so, already have submitted the Honorable Supreme Court judgment that since it is a taxing entry, strict interpretation is.
Problem is that not that. Question is that how you have worded the taxing entry. That has created a lot of problem. You say it is not used as a cattle feed.
That has been deleted.
No, that is the deleted.
Not deleted.
Deleted later on, not now.
For the period.
For the period, it is still there.
Your lordship, at page 7.
No, 6 of petition.
7.
6 of what?
Page 7. Both the previous provision and subsequent provision I have narrated. The provision for the temporal period, that condition has been deleted. Only bran is taxable 4%. And he is selling bran. Your lordship, please 7.
Come to the notification.
Your lordship.
This entry, I think, below you have given the reference to the notification.
Your lordship, page 7, your lordship.
Page 7.
Your lordship. Page 7, this is the first table, is the provision, is the till 8 February 99. Yes. After 8 February 99, this except so and sold as cattle feed has been deleted. Only bran is taxable at the rate of 4%. So the second table, the right hand column table, is the entry for the improved period, your lordship. So for the improved period, there is no condition, only taxable.
Yes.
So for that reason, since the entry is very clear, there cannot be no interpretation otherwise, your lordship.
I was really thankful that I have not read this with the date.
I'm sorry.
1999.
I'm sorry, very sorry. For the impulse.
So, Mr. Mohanty, that we cannot interpret anything now. It's directly made taxable.
My specific case is
no, because these all the arguments so far you have made. Now it's a specific entry. And so that 30D becomes irrelevant.
If my lord hold that 30D,
cattle field is there, but those in a branch,
irrespective of the fact,
it is a special provision now. It becomes a special provision now. That is the problem. You know, if there is any juxtaposition of the general
provision and the special provision according to the interpretation, even for the general statute. Forget about the tax statute. This special provision will take over.
Even then, since it's a beneficial provision and
No,
subsequent
it cannot. Sorry.
subsequent
Tax jurisprudence, you cannot do that.
and subsequent another judgment that I have cited, Lasik, with regard to the beneficial nature of the levy and on whom the levy ultimately raised. This honorable court in State of Orissa versus Phipson and Company, case 23, I have enclosed. There was a entry serial number 30 of the Central Sales Tax Act, which exempted from sale of goods of military personnel by the defense service installations. Phipson, the petitioner here, sold its commodities to defense service installations. The benefit, the exemption was denied.
No, the problem is that now there is no exemption. After 8th of February, this clause has been omitted. There is the only clause that has been retained, Blan 4%. Nothing exemption, no. So
I submitted a little bit further, Lasik. What had happened, so in this case...
What has happened, we'll not look into that.
Just a little bit further, Lasik. Just 1 second. This provision was interpreted that if the sale of by Phipson to the defense service installations is taken to be taxable, the ultimate burden of tax will lie on the military personnel. So this honorable court, taking note of the amendment that came into effect subsequently in 8th of February 1999, came to hold that the MP was amended, and it amended to the effect the sale of goods to defense installations located inside the state of Orissa for resale to military installations or personnel. That was expanded. So looking at the subsequent notification, this honorable court came to hold, took note of that and came to hold that since the benefit of the to the military personnel will be restricted if this is interpreted not to be exempted to the petitioner here.
So that is the problem here. The exemption clause itself has been taken back by you of this amendment. But there is no question of bringing any interpretation relating to the exemption.
Section 30D, how
erased out.
They could have
what they have done. How can they take the help from the provisions?
If philosophy ignores the subsequent notifications of 2001 and 2002, then
I am to ignore.
Lordship. Then
because it is we are dealing with the text on there. I have no special jurisdiction for that purpose. So that's it. Okay, Mr. Mohanty. Mr. Sunil Mishra, run a standing council, commercial tax. You are only commercial tax.
Your CT and GST.
CT and GST. And also heard Mr. A.K. Mohanty. You are Mr. A.K. Mohanty.
I'm A.K. Mohanty.
A.K. Mohanty and counsel appearing for the SSC.
Lordship, along with Mr. Anand Das, additional standing.
Anand
Das.
Along with Anand Das. Stop. By means of this revisional application filed under Section 24 of the Orissa Sales Tax Act 1947, credit Rule 52A of the Orissa Sales Tax Rules 1947. The order dated 24/11/2001, Annexure 2 to the ultimately you challenge that order. Both the order you are challenging?
Your Lordship, I am challenging the tribunal's order. Because assessment order has been confirmed in past.
Challenging the order dated?
Order dated, Your Lordship.
8/1/2016.
Passed in essay number 1459 of 2001-02 by the full bench Orissa Cell Text Tribunal, Answer 3 to the petition. So, the said second appeal, the order dated 24/11/2011, passed by the learned Eastern Commission of Cell Text in appeal case number AA-167-CUIE-2001-2002, whereby the whereby it was observed that do you have a better copy of this order?
First,
Answer 2. No, this is a typed copy, not only typed copy. Let me see. There is a reason. It's black part.
carbon copy. It's copy better.
Let's see, original.
I got it. All right. Now I've got it. It has been held as follows. Quote, sale of bran was made accessible to tax 4% with effect from 8 to 1999 by Government of Orissa in Finance Department notification number 86/99 dated 8 to 1999 with the deletion of the condition within quote, if sold for use of cattle feed, unquote, as a cattle feed, in view of the code of the codal provision, this codal provision, the appellant is liable to pay Orissa sale tax at 4% and surcharge due on sale value of wheat bran of rupees 1,17,32,810.75. And this is exactly what LAO has adopted for the purpose of his assessment of tax. In view of the above discussion, it became quite clear that contention taken by the learned LA to keep the sale turnover of wheat bran outside the scope of taxation merits no consideration, and therefore the same fails. The LAO is found justified in disallowing the appellant his unjustified and illegal claim of deduction made towards sale of free goods, needing no interference from this forum. Accordingly, the gross turnover decided by the appellant and adopted by the LAO is upheld in appeal. The taxable turnover is redetermined at rupees 7 crore 28 lakhs 87,899.99. Tax including surcharge due comes to rupees 32 lakhs 58,000. What is the figures? 843.28. 843.28. Thank you. That's the appellant. The appellant. Having already having paid rupees 27 lakhs 27,000 239.00 under section 36 of the OST rules is now required to pay the balance amount of rupees 6 lakhs 25,604.00 as per this order of the appeal. So, it has been stated that, unquote, the appeal was therefore partly allowed. So, against the said order of the first appellate authority, the dealer opposite party have filed the appeal under section 12(4) of the Orissa Sales Tax Act, second appeal. 12(4) of the Orissa Sales Tax Act, by the impugned order, the said appeal has been allowed by setting aside the order of the first appellate court dated 24/11/2011. So, in order to interfere the order of the first appellate court, it has been observed that it has been observed inter alia that in SRO number 150/2001, which was simultaneously issued with effect from 1/4/2001, a new entry in the list containing exempted goods at serial number 2 is inserted, which reads as follows, quote, to bran other than rice bran. Stop. The appellant submits that amendments as given above clearly indicates the intention of the legislature that it never wanted to withdraw exemption on sale of wheat bran, which essentially is a cattle feed. For the proposition in law that a subsequent amendment can be looked into for finding out the intention of the legislature, the appellant relies on decision of the High Court of Orissa in Lakshmi Agency and Pathera versus State of Orissa, 1995, 1 Wheeler 671. So, thereafter it has been observed, so far as the entry 30D is concerned, it has been repeatedly held by the Honorable High Court of Orissa that the commodities mentioned under the said entry are only enumerative and illustrative and not exhaustive. Stop. Anything that is in common parlance and trained parlance known to be the feed or the fodder would come within the said entry and would therefore be entitled for exemption. Stop. Thereafter, the tribunal has also observed it is well settled that if conditions or the restrictions placed in the matter of exemption militate against the purpose for which the exemption has been granted and have effect of defeating the purpose to large extent that it cannot be upheld. Stop. In the present case, exemption is provided under entry 30D has been brought in with the intentions to benefit the farmers by making available to them feed and fodder at a reasonable price, and therefore any interpretation or restriction which would make such commodities dearer would defeat the purpose and intent with which such exemption was granted. In view of those discussions, as we have noted, a separate paragraph, the tribunal finally observed that the sale of wheat bran is tax-free as contemplated under entry 30D of the tax-free list during the period under dispute. And accordingly, the demand to the tune of rupees 6,25,604 was quashed. So Mr. S. Mishra, Land Council, appealing for the revenue, has stated that the said interpretation is unsustainable inasmuch as when the general provisions are contrasted with the special or the specific provision in a tax statute, only the specific provision would prevail over. That is a contention. In this regard, he has referred to the relevant entries in the Orissa Sale Tax Act. Stop. In the Schedule 1, the Schedule 1 is the tax-free list. Entry 30D provides the exemption in the following manner. Sale of feed and fodder such as husk, straw, hay, grass, well cake and manufactured mixed balanced feed for cattle, poultry and pig shall be tax-free. Stop. Similarly, the Schedule 2, where the taxable items are listed, the goods known as bran has been described, and tax was made at 4%, subject to condition and exception that if sold for use as cattle feed, that will be exempted from tax. Stop. As we have noticed, and also very specifically recorded by the First Appellate Authority, that by the Finance Department notification number 5281 CTA-115/98 F within bracket SRO number 81/99 close the bracket dated 8/2/1999. The said entry 2 under the Schedule 2, Schedule B, I think not, it is Schedule B.
A is exemption, B is the purchase tax, C is the sales tax. tax on sales turnover. This is brand, this is under which schedule then?
List sale tax, list C, entry
List
15.
C, huh? List C. The entry has been substantially modified. So it has been, the notification has categorically deleted the provision quote if sold for use as cattle field. Stop. Therefore, since 8 to 1999, brand is directly under the taxable commodity with tax liability of 4% on sale. Stop. Mr. Mohanty, learned counsel appearing for the SSC, has stated that by subsequent the change in the statute, the brand has been made completely tax-free, which is inconsistent with entry 30D. Stop. Behind the entry 30D, there is a welfare state policy for welfare of the farmers. Stop. According to Mr. Mohanty, the generally, since the brand is in the common or the commercial parlance is known as feed and fodder, therefore the 30D will have sway over the other provisions. In this context, Mr. Mohanty has relied a decision of this court in Lakshmi Agency versus State of Orissa. Colon 1995 1 Wheeler 671. In that decision, this court had occasion to lay down that the subsequent statute can be clarificatory in nature. Stop. In that case, the contention of the SSC was that insertion was intended to be clarificatory and to avoid contradictory assessment cannot be brushed aside lightly. It has been observed that it can also be said that the expression, quote, including de-oiled cake, unquote, was introduced to avoid any anomaly and conflict of views and to put the true meaning and effect of the term, quote, cattle feed, unquote, beyond the shadow of doubt, and to clarify that it also includes de-oiled cake. Stop. According to Mr. Mohanty, the said principle can also be applied in the present case, looking at the subsequent change in the statute, whereby the brand was included under 30D and making the same as completely tax-free.
Stop. Having appreciated the submission of the counsel for the parties, the only question that is paramount and to be responded by us is that whether in presence of a specific provision, the provision generally in nature can have any sway, or whether in the presence of specific provision in a state statute, the court can go for interpretation by taking additional aid from the subsequent statute or not. Stop. According to us, by enacting the notification dated 8/2/1999, the state has clearly excluded done from Section 30D as the specific as entry 2 under list under Schedule C is a categorical, and it provides bond is accessible to sale tax at 4%. When the state statute is clear, unambiguous, and direct, court is not generally called upon to interpret such statute. Court has to act upon the provision of the said act. As such, the observations based on which although the first appellate court was reversed by the tribunal, is according to us is uncalled for, and the interpretation they made is not only unwarranted in the present context but also inappropriate. Hence, we quash the impugned order dated 8th January 2016, Annexure 3 to the writ petition, and restore the order of the first appellate court dated 24/11/2001, Annexure 2 to this writ petition. In the result, this petition stands allowed. However, there shall be no order as to cost.
Gratefully.
Item 9.
May please your lordship. This is a public interest litigation, my lord. Matter relates to installation of CCTV camera and fire safety measures in the premises of SB Medical College and Hospital, my lord.
Yes. The last matter been filed today. I'm giving and serving a copy to Mr. Mahanti also.
This serious matter just now they are giving.
It is always
life and property in danger, my lord. Life of the patient and the attendant are in danger.
How CC camera life is in danger right now?
Fire safety are in danger.
My lord, this SB Medical College was established in 1944, and since that period it is continuing without this year.
Without that, but frequently fire devastations are occurring. That is also very much known to the general public. And
now the thing which I gathered knowledge from the department.
We asked for the security survey of the entire hospital.
Security survey.
My lord, I may be permitted to place the relevant order which has been passed by this honorable court.
Exactly.
That is the order. My
August order.
Para 7, my lord. Order dated 14 August 2023 in order 9, my lord.
Yes.
Para 7, my lord. Para 7 is a relevant order. I want to place that order. Having considered the urgency, let the matter be listed again on 11 September 2023. In meanwhile, the opposite parties shall come up with a comprehensive plan with the date by which the fire safety measures as required will be put in place. We would expect that bureaucratic red tapeism will not come the way. Proper design for the fire safety measures shall be made within a short while. A comprehensive affidavit dealing with installation of safety measure shall be filed by the next date, my lord.
Now you see their affidavit.
Affidavit
They have
is there.
answered these queries of the court in paragraph 4.
Fourth, my lord. His humbly was established. Keeping in view the number of buildings were constructed. Such no plan.
Lot of new buildings have come up inside the campus, and they are having all plans and all these buildings.
Mr. Mohanty, just I want to know, is it the response to the court's query and the nature of affidavit court asked you to submit?
No, man.
Do you think so?
My lord, para 6 may kindly be seen.
I have seen this para 6. This is the most evasive paragraph.
My lord.
Read para 6 for everybody.
We'll file a better affidavit.
Well, why you are taking time? First of all, very clear. There is a 3-step approach you have to take. Number 1, you make the survey. What is the present status of the fire safety? With the personnel from the fire service department.
Yes.
And they ask them to give you the fire safety plan, including the existing and the new building.
Honestly speaking, but to do all these exercises, so long period is required.
You have not taken any initiative. Come before the court if you are finding the time provided by the court is short.
My lord, I will give a better affidavit with all these data.
Well,
lordship.
You should ask the officer how much time it will take.
That must be specific, my lord.
No, that is type must be specific.
You just try to cooperate with it because SCB Medical College, all these matters are also.
For this medical college involvement is very least. They only give access to the fire personnel experts.
Yes, we have to
supply them the
requisition. We have to requisition the fire safety
authorities. Building the evacuate land in the building. If certain thing happens, how you will evacuate the patients, your personal staff, everyone. These are the important things you have to take care of.
As those points from where you'll take water, all that is there, like it has been done in the High Court also.
Yes.
But there it's a larger area, so plan has to be more detailed.
That exercise, your lordship may. The plan of action I will submit before your lordship on the next date regarding all
How
this.
much time do you require?
15 days time maybe.
Already I'm speaking 15 days is the last chance. This is the last chance. Today is 11th. I'm fixing the matter on 26th. Is a working day?
Maybe fixed on 29th. I will.
Also find out whether new buildings have those fire alarms.
Yes, that is also. These are all.
Nothing is there.
All the Friday is special matter is fixing it. Okay. We'll sit for this matter on Friday. Usually do not take the division bench matter on Friday.
29th.
Yes. At the request of Mr. D.K. Mohanty and additional government advocate appearing for the state opposite parties, then the matter will be listed on 29 September 2023. So today, the opposite parties have filed a very short affidavit in terms of our order dated 14/8/2023. By the order dated 14/8/2023, we have asked the opposite parties to submit a comprehensive plan with the date by which the fire safety measures as required will be put into place. Stop. We have also asked people to lay the proper design for the fire safety measures within a short while. But instead of filing a comprehensive affidavit dealing with those two very important aspects relating to the SCB Medical College, they filed a short affidavit giving a brief outline what is required under Rule 13(1) and Rule 14(2) of the Orissa Fire Prevention and Fire Safety Rules 2017. We are really constrained to observe that we did not ask the lesson about the rules we wanted to build up the appropriate fire safety measures in the SCB Medical College, supported by the well-coordinated network of the CCTV cameras. So at this juncture, Mr. Mohanty has prayed for some more time to file the comprehensive affidavit, including the fire safety plan and other measures that are required to be taken for ensuring the fire safety in the SCB Medical College. Such affidavit shall be filed within 26th of September 2023. Let the matter be listed on 29th is already there. Yes. Mr. Mohanty, just record the name of Mr. Mohanty.
I have got one. A copy of the order may be given to me.
Mr. Mohanty and Council has appeared for the petition. A copy of this order is supplied to Mr. Mohanty and Regional Government Advocate.
I have got small submission to made my lord in this case, that a letter has meanwhile has been issued by the Chief Fire Officer to the Medical Authority, my lord. That is in flag F of your lordship brief. Flag F, my lord. Letter has been issued to take action, my lord. Flag F, my lord. A letter of Chief Fire Officer, Orissa to take necessary action.
Council has brought to our notice a letter of the Chief Fire Officer within bracket SAG, letter dated 29/8/2023, whereby the fire officer Central Ridge Kotok was asked to take the necessary action in consultation of the superintendent of SCB Medical College and Hospital, Kotok. But in the affidavit, there is no reflection what has happened in the aftermath of the said letter dated 29/8/2023. In the said affidavit that will be filed by the opposite parties, the actions taken in terms of the said letter dated 29/8/2023 shall also be included.
Yes. And a copy of that letter has not been given to us.
All right, it is still directed to supply the copy of the letter dated 29/8/2023 to Mr. Mohanty and Council appearing to the petition.
That letter directly
is copy sent to the superintendent because
a copy of
order was supplied to the Director General of Fire Services.
Then your lordship may direct us out the copy to me also, register. Because I have no
government officers letter, we shall ask.
Yes, okay, I will get it. Sorry.
Item number 10. May please your lordship. This is a my lord, PIL matter, my lord. Matter relates to my lord, protection, preservation and conservation of water bodies of Kotak city, my lord. This matter appears today's list as per order number 22 dated 8 August 2023. Relevant para is para 3. Earlier to passing of this, the said order, this honorable court has passed an order in order number 20 dated 19 January 2023, my lord. The relevant paragraph of the said order is as para 1 and para 3, my lord. If your lordship permits, then I assess those paragraphs which are relevant. This order has to be complied with by both the parties, the petitioner as well as the opposite parties. Copy of the para 1, my lord, I am going to place para 1 of the order dated 19 January. Copy of the affidavit dated 17 January 2023, filed by the opposite party number 1 and 2. Is served on the council for the petitioner today itself. He is permitted to respond to the said affidavit before the next day. Next, then I will draw your lordship kind attention to para 3 of the said order. A further affidavit be filed before the next date, giving and
what happened? They have not filed the affidavit.
They are filed affidavit. Minor, I will also place. They are filed on 14 July 2023, but they have not complied the para 3, my lord. They have not given anything in their affidavit regarding update progress made of the water bodies, my lord. On the other hand, what they have done, they have only given the government circular, my lord. Showing the SOP. I would like to draw your lordship kind attention to their affidavit dated 14th July 2023, my lord. The affidavit that has been filed by the opposite party is dated 14th July 2023. What they have did, they have only government circular showing standard operating procedure, which is at Annexure A at page 4 to 51, my lord. Copy of government circular showing standard operating, whereas this honorable court wants that they should give specific and concrete the progress of the water bodies. They have not given. They have only enclosed copy of the government circular showing the standard operating procedure, my lord, which is at page 4 to 51, my lord. Copy of government circular showing standard operating procedure, my lord.
Yes, that I have seen.
My lord. On the other hand, my lord, I want to submit for your lordship that day by day the condition of the Jalasayas of Cuttack city is deteriorating and become precarious. For that reason, I have filed a miscase, my lord, which has been also fixed today for hearing. The miscase number 12037 of 2023, my lord. May I place that?
Yes.
My lord, I would like to place, my lord. This interim application has been filed by the petitioner basing on a news item dated 24th July, wherein it has been reported that by filling up the water bodies, construction is going on, my lord. Basing on that letter, that is Annexure 1, my lord, at page 8, my lord. My lord, what did my
Yes,
my lord. Basing on that news item, petitioner has filed application before the RBC Cuttack, my lord, who is the competent authority who is examining whatever this matter, my lord, and requested him to take necessary steps and specially stop the illegal construction and take necessary action for renovation and.
Have you filed any response to that, Mr. Naik?
They have not given any response to this.
Specific allegations have been made in this.
RD similar to the
RDC.
The Revenue Divisional Commissioner.
Oh, there is Mr. Mohanty.
Yes, I am to sponsor this because he is appearing for CMC.
Okay.
But the RBC as well as the collector, Cuttack and sub-collector and Tahsildar, my lord.
Miscase copy देंगे.
So, would you like to file any of it?
Yes. I will file response to that IA.
The matter will come on 18th, filed in the meanwhile.
18th.
Illegal construction is going on, my lord.
On the same day, 29th, your lordship may fix.
No, my lord. 2 days, my lord.
18th is a short matter. You take instruction and file it. Because overnight changes cannot be, but they should be given a shake. No, that what they are planning to do.
Yes.
When a matter is coming in the newspaper, usually in the earlier days, the cutting used to go to the concerned authority to take note of all these things and take the necessary action.
My lord, we have also, basing on that, we have filed application before the concerned authority. My lord.
Yes.
That IA,
the concerned authority is
IA is this is one.
IA copy is not solved, right?
Already solved.
No, it is not solved.
The receipt is
037/. And Mr. Mohanty served one copy.
Another copy, my lord? In course of the day?
All right, in IA 12037/2023. Stop. This special application has been filed in this public interest litigation in WPC now for 951 of 2019. On the is seeking the direction on the RDC within Meghat City Cuttack to take steps conduct the water logging, which according to the petitioner is due to sheer inaction of the authorities to stop filling up of the tanks. So, in this regard, one representation has been filed on 31/7/2023. Mr. Mohanty Learned Council has apprised this court that even thereafter no action is visible. So Mr. D.K. Mohanty Learned Council appears and urges for a short accommodation for filing a response to the said application. Let the matter be listed on 18th of September 2023. 21st September. Okay, 21st September. In the meanwhile, the response affidavit shall be filed. So, Mr. D. Naik Learned Council appears for the Kotak Municipal Corporation, CMC. Okay.
Copy of the order may be given.
Copy of the order.
Connected matter will also be listed.
First appearance,
I am in person, Mahila.
21st.
21st. That is also PIL, I am in person.
That is tagged with that case. Patra's case is tagged with that PIA. So it will come and that is also water parties.
Because your ship,
the second
nowadays these dilapidated tanks became the developing all types of diseases, spreading all types of diseases.
Of a similar accusation they have also made. Their accusation is something different because they say that filling up of the tanks is a real reason. The waters are not getting into the tanks, and that is the reason.
That's because of the fact that this has been encroached. Because I particularly let them one tank, I would say,
then you can furnish also the much
because only they have filed one affidavit on in the month of August 22 and doing nothing thereafter.
All right, we'll hear you on next day. We are fixing your matter along with this matter also. Yes, next.
Item 14, there is a direction for personal appearance. My officer is present.
My lord, this Jalasa matter has already been decided by this honorable court, my lord, in the year 2012, my lord. My lord, 115 CLT, my lord, page 407, my lord, Justice B.P. Das judgment, my lord. And long back, that has already been decided. It's the cover matter. Till then, the state is not taking any steps, my lord.
Actually, the administration is not doing anything, Your Lordship.
They are doing something.
Rather, now it is a source of spreading dengue, malaria, and all other types of diseases.
Very today, no time is next call the matters.
Item 14, personal items of possible.
Yes.
Item 14.
Pursuant to order dated 31st August 2023, my officer is present. I have also filed a compliance affidavit on Friday. That is not there. I'm seeing on the
What is the explanation? Where is the officer?
Well, in fact, in my affidavit, I have stated that the order which is now sought to be implemented, that has undergone a change. Virtually, that has been set aside. I have explained in, and I have also passed the, in fact, challenging that order, the appeal was filed for the sub-collector. Sub-collector confirmed the order passed by the revenue officer. Then matter carried to the revisional authority, that is the ADM. ADM has set aside the order, remand the matter back to the authority concerned with certain observations.
No, man.
So now
no set aside is there.
The remand means what?
Only remand.
Yes.
So if you are aware, they have not disclosed in the writ petition that such an appeal was filed, and was filed, and such developments that has not been disclosed in the writ petition.
You are asking for implementation of an order which has been varied subsequently. So how can that be?
Madam, my response on that, the
due to the remand basis upon the revision.
Have you indicated in your petition about the remand and subsequent orders?
Annexure 2.
Government.
Yes, madam, annexure 2.
Yeah.
The revision. 107 of 87.
This was filed
That is the order 7. That is the order is clear order. But the ADM has remand that this is the order of the Board of Revenue has not dealt out. And this order has been challenged with the High Court and Supreme Court also, which has confirmed. The order annexure 2, which was confirmed.
Yes, today's affidavit, my lord, is page 5. Page 5, my lord, please. And annexure A by 5.
Have you got a copy?
Yes, I have.
Yes, I have.
Annexure A by 5 starts from page 5. That is the order of the revisional authority in OLR case number 1 of 2007. As the facts are there, let's kind turn to page 6. Page 6 towards bottom, my lord, we can see 5th line from the bottom. After dismissal of the SLP,
Yes.
after dismissal of the aforesaid SLP, the revenue officer Kanika reopened OLR sealing case number 47 of 74 and disposed of on 5/3/2004. This order is now sought to be implemented, holding that the gift deed registered on 24/12/1997 is hit under section 40 of the OLR and the same has been created in order to frustrate the legal position of OLR and accordingly disallow the claim of the petitioner to record the properties included in the gift deed in his name. The revenue officer further disallowed the claim for filing choice to allot the land and substituting the properties allotted in the retention side, granting liberty to raise this claim in appropriate forum. Against the said order of the revenue officer Kanika, this petitioner preferred OLR appeal bearing number 2 of 2004 before the sub-collector Kendrapada, and the sub-collector Kendrapada by his order dated 23/5/2007 dismissed the appeal and upheld the order of revenue officer Kanika. The petitioner challenges the order of revenue officer in OLR appeal number 2 of 2004, which is dismissed on 23/5/2007 by the sub-collector. Hence, this revision. During course of hearing, the land council appearing by the petitioner raises some issues and questions of law involved in the order dated 23/5/2007 of the sub-collector Kendrapada. While directing the revenue officer to rehear and dispose of the 15 numbers of cases under section 36A of the OLR, the appellate court should have allowed the appeal since when the entire properties were declared as surplus land by the revenue officer, the case under section 36A of the OLR Act is not maintainable against government land. Both the courts below failed to interpret provision of section 52 of the OLR Act and wrongly held that the properties cannot be devolved to the legal heirs of Manjari Devi and vested in the government, ignoring case law and interpretation of statute reported in Volume 44, 1977, CLT 449 and 1990, Volume 2 LR 199, that at any stage or even after the land is vested in government, the landholder is entitled to exercise option on conditions of substituting land. The restriction on transfer of land under section 40 of the OLR do not prohibit acquisition of land or any transfer or partition of properties in blanket manner. If a person does not hold land in excess of the ceiling area, such person is free to alienate the property within ceiling area as per case law reported in Swansu. Thus, the property is transferred by the ceiling holder Manjula Manjari Devi by way of gift is not hit under section 40 of the OLR Act since the said property is within her ceiling limit. Both the courts below have also failed to examine the judgment of OLR revision number 107 of 87 to the effect that the member board of revenue is directed to keep the properties sold or transferred by the ceiling holder after 26/9/1970 in his retention site by modifying the order dated 27/1/1984 passed in OLR case number 47 of 74. But the revenue officer, instead of modifying the said order in view of the said transfer, has vested the properties in government, declaring it as surplus land. When the member board of revenue in finding number 3 and 4 of the judgment dated 8/10/1993 passed in OLR revision number 107 of 87 held that pending civil suit, the properties allotted to Amar Kumar Dev should not be taken away or vested in government. The revenue officer should have acted according to the status quo order passed by the Civil Judge India Division Kendrapada in civil suit number 138 of 92 without vesting the properties in government. In aforesaid submission, the petitioner prayed to set aside the orders of the courts below which are under challenge in this revision. Peruse the records and the case law cited by the petitioner, it appears that the points of law
raised by the petitioner and the orders of Honorable Member Board of Revenue, Odisha and OLR revision number 107 of 87 have not been properly dealt with by the Revenue Officer Konika. Hence, the issues raised by the petitioner may be examined by the Revenue Officer Konika in accordance with the affording opportunity of hearing to the parties concerned. Accordingly, this case is remanded to Revenue Officer Konika for disposal. Yes. So
Thereafter, it is pending.
Yes.
Since 2013, it is
So
pending.
thereafter,
That is his allegation.
yes. So his allegation is 2004 order is not being implemented.
My as per submission matter in 87 in the first order. Come straight first. This question is very important. What Mr. Muduli is raising. Yes, ma'am. Come to your prayer.
I am the order of the unnecessary one mallet and
this is a 5/3/2004 order.
Yes, ma'am.
Yeah, all says that order is no more in existence. In view of this order, the passed by the revision law.
Only remanded on the ground that the 107
it's a fresh hearing of the matter. Not only one ground or two grounds, then remand on a specific ground is made. It has to be recorded in the order itself. This remand is limited to that.
The order passed basing upon this order. The Tahsildar has passed the order.
You are saying that this implementation is not possible, but the revenue officers should complete the proceeding within a reasonable time and preferably within this 31st of October. Is it possible?
2013.
I filed the list of event minor.
No, nothing is not
As per the procedure, he said that at least 6 months time is, but you also may keep the time till the end of December. So that
Mr. Muduli, procedure means 2013 he has directed for issue notices.
Proceeding is already there.
Proceeding is there, but it has not been opened after 2013.
There is no question of issuing the notice because the remand order is there. Only you have to communicate the day.
Only so far as section 36A is a statutory remedy to the tenants. Because once they are settled.
And thereafter it seems.
But this, I accept 33A.
All right, 31st December.
Yes.
अरे disposal करो. नहीं.
Pardon, Mr. Brindavan Raut, and counsel appearing for the petitioner. By means of this petition, the petitioner has asked this court to direct the opposite parties to comply the order dated 5/3/2004 passed in Whaler Sealing case number 47 of 1974 and to correct the records of right in favor of the state government of the vested land. So, the petitioner has complained of deliberate inaction and taking the due steps in terms of the order dated 5/3/2004. Stop. The opposite parties, number 5, today has filed a compliance affidavit in respect of the orders dated 28/8/2023 and 31/8/2023. So, Mr. Muduli has also produced the order dated, a copy of the order dated 10/5/2013, passed in Whaler revision number 1/2007 by the said order. The order dated (5/3/2004), Annexure 1 to this writ petition has been set aside, and the case was remanded to the revenue officer Konika
to decide in accordance with law after affording the opportunities of hearing to the parties. It appears from the records produced by Mr. Moduli under Annexure P5 of the affidavit filed on 8/9/2023 that after the order of remand, due notice was issued for the appearance of the party. Have you issued the notice?
Yes, your
After receipt of the remand order? Notice to the party.
he has joined only in the month of October.
Ask him whether from the records he can say.
Your Lordship can see this order after remand. Your Lordship can see page 9. Order dated 35/2013.
That I have recorded.
Yes, page 12 is the operative portion. Thereafter, Your Lordship is
Put up this case after due compliance. So what has been done after that? Even if he has joined, while taking out this order, he must have seen what has happened.
only after last order when I inquired about the details, all these things can come.
Page 12, the order passed. Unfortunate that after the order dated 35/2013, by which the compliance of the service was directed, no order has been passed. So we direct the revenue officer Kanika to ensure the service is made upon the parties by 30th of September 2023. If required, a special messenger may be engaged by the revenue officer. Stop. Stop. The said case, the said case the Whalers Selling Case number 47 of 74 shall be disposed of by any rate by 31st of December 2023. So in terms of the above, this petition.
My only there, my lord, the land was already decided by the Honorable High Court and Honorable.
Make a submission there. We are not.
No, my lord. I am not interested party in this case.
No, you are. You want to the land to go to the government only. That we have understood.
Yes, ma'am. My responsibility is the land selling surplus land will illegally sold out. As per this order, the Tahsildar and the authorities are kept pending and sold the lands, madam. When the
settled,
sold, when I bottom the land is standing name of the illegal selling holder, illegal heirs. Or number of lands already sold. I am given the mutation copy of the records, my lord. Therefore, no further selling. Now, the land of 14 acres are going to sell.
In the said selling case, no further settlement or sale shall be caused.
Yes, ma'am.
Just not before that. Working days
will be 1st January.
January calendar is there. 24th. Monday is 1st January. By 1st January of 2024. But I just this petition shall be at liberty to approach this court again if he finds the grievance he has raised has not been addressed by the state properly. All right.
With you acknowledgement, item 12 loss. We will call tomorrow.
3rd January.
Copy of the order.
A copy of this order is supplied to Mr. P.K. Mudulil and additional government advocate.
Personal appearance be displayed.
Personal appearance of Mr.
Tahsildar.
Names.
Ashok Kumar Behuri.
Mr. Ashok Kumar Behuri. The Tahsildar.
Dehuri.
Okay, Dehuri.
Tahsildar Konika.
Tahsildar Konika is dispensed with. Is what matter?
Yes, item 12. It is a draft disposal matter, Milos. Only I have to file a complaints affidavit. Tomorrow, Milos, will be taken over the past date.
Tomorrow. There's no time
Item number 15. Sorry, I am in virtual mode. Item number 11.
11, we have already passed order.
Item number 11.
All right, yes.
Item number 11. Number 15. Item in that elephant matter. Day after tomorrow.
11, we are fixing the matter on 24th of September again. 25th? List and sentences, there is no time today to take up the matter.
Lordship, item 15, your Lordship, fixing to 24 September, Lordship.
One, 24th September?
Lordship, your Lordship is taking up 15.
All right, it will come on 24th September. Yes. 24th September.
Lordship, in the meantime, what I request,
yes.
Lordship, what I request, the forest department may take step, particularly in the forest range of that Ranpur. There is the two wild tusker, they are disturbing to that area. They may relocate it and they can take it to that Chanka area where they can placing the.
That may be considered on 25th, my lord.
All right. But you look at it. All right.
This step only.
Item 11. So Lordship fixing it to
24th is a Sunday, man.
25th.
25th.
My matter may be on 26th. Item 11.
All right, 26.
Lordship, on that day, your Lordship, on this matter, your Lordship directing the Dr. Nair to present the views, Lordship.
No. Dr. Nair is here. I cannot direct his presence now.
No. I am asking presence, Lordship, on 24th, Lordship. On his any other officers can also address the issue, Lordship. That's
all right. This Mr. Mohanty is there. He will take care of this. Okay.
Submission item number 1.
May I please, your Lordship? Order of the learned single judge is under challenge. That is Annexure 7. That starts with page 90.
Yes.
My lord. My prayer before the learned single judge is, your Lordship, that is certain allegations, a charge that framed against me. My basic point, that is, I have challenged on two grounds, on the ground of technicality and also on the merit. Technicality, your Lordship, higher authority, my appellate authority, has given a direction to the disciplinary authority that you dismiss this fellow without inquiry, without framing of charge. On the basis of that, your Lordship, for that reason,
Mr. Mohanty, don't change the facts.
That is, your Lordship, that is only one point. That is very.
I should not have interjected you. Your framing of your charge, nowhere refers that you will be dismissed or you will be, reinstated. You must say that there is a background. This initiation was post that letter. There you must stop. But you are saying that he has given a direction to dismiss me without so please, that creates the impression that there was an order of dismissal without any.
That is, your Lordship, with your Lordship's permission. Read petition, your Lordship, Annexure 11, your Lordship, just have a glance. That starts with page 45 of the read petition, your Lordship. That was initially filed before the tribunal, then it was transferred to this court after abolition of the tribunal. May I place that annexure, your Lordship? That is, your Lordship will see, that is a letter written from read petition page 45, your Lordship will see. There is annexure 11.
In the top, your right hand side, it has been written confidential, and in the left, your lordship will see.
In our file, it is page 33.
Ours is 30, mine is also 33. My lord.
20th October 2011.
My lord.
20th October 2011, Mr. Mahanti.
My lord, 23, but that is in the.
So page marks are not matching.
That is in, there is some defect in the pagination of that, your lordship. Did my lordship get it? That?
Yes.
My lord. That is a letter written from the Director Land Records of Survey Consolidation to the settlement officer. They have written the R.K. Chaudhary IAS. He has written it to the Dhiren Patnaik, settlement officer Cuttack. This settlement officer Cuttack is my disciplinary authority, is my appointing authority. Appellate authority is the director. Director has written the letter, your lordship, with your lordship's permission, I am placing. Sir, I am inviting a reference to the subject cited above. I am to say that the applicant Sri Behera, the present petitioner, was given appointment as on under JC establishment while your office order number such dated such after imposition of strict ban appointment of NMR, DLR, watch charge and JC employee while finance department circular number such dated 17/4/1993. The said appointment order is purely illegal and unlawful. The action of the then settlement officer is unauthorized and violation of government order. Further, it is stated that applicant Sri Behera has no locus standi to continue in service since his appointment to the post is done illegal. The Apex Court of India has delivered a historic judgment that an illegally appointed person has no right to continue in service. Accordingly, you may refer to the said judgment and dismiss the applicant from service, invoking the provisions of Rule 18(2) of OCS CCA Rule 1962. Besides, you are advised to report the name of the then settlement officer and other staff who are instrumental in giving the illegal appointment and submit the draft charge for taking steps for joint disciplinary action against them under Rule 15 OCS CCA Rule 1962 within a fortnight. Under the above premises, you are requested to take prompt action on the matter and report complaints to this directorate within a stipulated deadline. This is the letter. He has already used that word dismiss. That is the order of the appellate authority, your lordship. On this technical ground, your lordship, I challenge that. And on the merit, your lordship, I am coming to. This is one ground.
No, this, yes, word dismiss is not the very correct word to use in such communication.
My lord.
Perhaps he intended to mean termination.
My lord.
Because against the government circular, that nobody should be appointed in such capacity.
My lord.
The appointing or the engaging authority has appointed you.
My lord.
So consequentially, this authority asked him that he should be terminated because he was illegally appointed.
My lord, your lord.
Right? This is, you cannot have the foundation to build up anything over this comment because you have been given opportunity. Charge memo has been filed to you, but you have not filed the written statement.
My lord, I have not filed the written statement.
And single judge has very correctly given you the liberal opportunity of filing the written statement.
My lord, but the thing is that your lordship is to see whether it constitutes misconduct, the charges framed against me. Because
that is a challenge.
My lord, that is your lordship, that is next annexure, annexure 12 is under, because the allegation is why you have filed so many cases before the tribunal, before the administrative tribunal and putting the administration into trouble. That is my fault. And your lordship will see 3 cases I have filed, and in all the cases I won, I got the financial benefit.
Just would you kindly come to this page?
My lord.
8 of your petition.
My lord. Read appeal, your lordship.
No. Your petition, original application.
My lord. My lord.
Read your relief.
My lord.
My lord is referring to para 7.
My lord.
Yes,
your lordship to opposite party to solve and pass necessary order to set aside annexure 12 dated 29/12/2011 as the same is illegal, arbitrary, and the applicant be given all the consequential and financial benefit.
What are you reading?
My lord, that is prayer person, that is relief short form.
Answer.
The Honorable Tribunal would kindly be pleased to admit the case and issue notice to the opposite party number 2 show cause as to why the case of the applicant shall not be allowed.
My lord, and after hearing the party, the case of the applicant be allowed. Then next paragraph, your lordship will see, and pass necessary order to set aside Annexure 12, dated 29/12/2011, as the same is
not there, Sumanti. In our brief, it is not there.
Your lordship.
Page 20.
Sorry to mention your lordship.
Yes, that revision here, the annex.
My lord, annex. That is
Not there, not there. We are having something else.
your lordship. Sorry for interruption. Your lordship may adjourn.
That document I am reading that from.
Your lordship may adjourn to some other day. I will present it and I am extremely sorry. Your lordship.
What about WPC OSC copy you are having?
My lord, that is.
So kindly take para 7.
My lord, that is I am placing your lordship para 7. What my lord, Honorable Chief Justice asked me, that is.
Did you amend your petition there before the tribunal?
My lord.
I don't think so.
No, your lordship, that has not been amended. The annexure 1, your lordship, the entire writ petition, that is original application along with annexure, that has been given. In the writ appeal, your lordship. Then,
So now you are in writ appeal, you are holding the writ petition
My lord,
also. So you are reading from the writ petition. It is
my
not there.
writ petition also, that is the annexure 1 of the writ appeal.
Don't have to go to the annexure. The original brief is there.
My lord.
So I know physical copy. WPC page 7. Page 8 rather.
But there is a discrepancy. If you have heard these things,
My lord.
by your typing out copy to annex the copy, this is completely an irregular act. Because this is the not telling with the original copy. And you are yourself is stating there was no amendment.
No, that is the.
There was no amendment you are telling how this can happen. There is there. You just see this. This has been added and pass necessary orders to set aside such and such in the copy.
Just that is the.
What Mr. Khunti also referred that annexure that is different and the original brief is different.
Your lordship, sorry for that.
Could you find?
Your lordship, may adjourn to some other day. I will present it correctly. There is some discrepancy.
Difference in the prayer in our original application.
This prayer is not there.
Yes, that I am saying that you have annexed that original application. That prayer is different from the original read.
Because original record is before us.
That should not have your lordship.
How this has happened?
No, that is your lordship. I am holding that original one.
No, this is a copy.
My lord,
this is not the original one.
my lord.
Huh?
Probably I think your lordship in computer or some person has been.
No, computer. This is not computer. It is a handiwork.
In computer, whatever is there, it is scanned only. Don't attribute anything to the computer.
Because here is the copy and signed copy of yours.
My lord.
It is not a signed copy, it is a typed copy, I think. It's very interesting. 4th June, everything is done, only this piece is changed.
Date is matching also. 4 January 20+.
So, it cannot happen.
Your lordship, probably what I think, that is when introduced of that A4 size paper, probably that portion has been left, I think, because that is.
No, Mr. No. This cannot happen. It is inserted without the authority of the court. It cannot happen because the original copy that you have filed before the tribunal.
My lord.
It is before us. It has been transferred to this court.
My lord.
And that is also signed by you.
My lord.
This is also signed by you.
My lord.
And it is typed, but these 3 lines have been added at the bottom of this paper. Do you have the copy of this record? This original record file? No, this is the writ appeal. I don't think so. This is how scan this copy was available to them.
Second copy also.
No, maybe this part was not scanned. All right, it's maybe so. This is because these three lines also just at the bottom of the page.
Maybe
that can be yes. All right.
Lordship, argument to Samazadda, it will paginate it correctly. Thereafter,
we agree to your contention. You advance your argument. That those three lines have been missed while scanning.
Now come to page 36. Or it is 36 of the original application. We are going to the writ appeal.
That starts with paragraph 5, Lordship.
Page 36 is annexure 1. That is part of annexure 12.
My lord. My lord. May I proceed? Sri Nadia Chand Begera, Amin of Kotak Leather Settlement Kotak, now working at Recess Office Kotak, is hereby directed to explain as to why your first JC appoint order in the post of Amin will not be cancelled, which was issued to you in the office order number 3696 dated 25/1995 after imposition of strict ban order on appointment in NMR, DLR, work charge and job contract by Finance Department Circular number such dated 17/4/1993. The said appointment is purely illegal and unlawful. On the above matter, the appointment in regular cadre as the establishment by the office order number such dated 16/9/2000 is illegal and unlawful. The above irregularity done by you attract the disciplinary action as per provision of OCS and CCA rule 1962 and you are charged as follows. Role is suspicious as he has suppressed the fact for self-interest, misconduct, malified intention for self-interest. These are the allegations. Now, your lordship, next page kindly see. Annexure 2, imputation of charter. Being aware of, with your lordship's permission, being aware of all the facts, you have very often filed number of OA cases in OAT to get financial benefit which is illegal, due and illegal OAT to get financial benefit which is illegal, due and malified intention to create imbalance situation to the
yes, Mr. Kuntia. What is the misconduct of the employee concerned?
In fact,
filing an original application before the tribunal can constitute a misconduct.
No, madam, this is not. In fact, the orders are not properly. That has not been properly ordered. But the fact remains that
you are reading your document.
Yes, that I have seen that. But it's the fact that he was appointed after the ban period. So according to your lordship, page 45.
All right, that tell us he was appointed after the ban period. Where is his misconduct?
No, that does not amount to because he has no fault with that. But while cancel, what has happened? Well, in fact, that in view of that finance department circular, any appointment.
I am telling you
that is not that
amount of the misconduct, and you are proceeding with. You have to find out whether there is any misconduct or not. This is the threshold test, right? How the employee can be just charged with the misconduct?
No, that does not
be charged with the misconduct.
Yes, that does not amount to misconduct.
Yes. So if it not that you are saying that since we are going to terminate him,
yes,
procedure is known to you, you'll give an opportunity that this is during
that's what should have been there.
No, there is no departmental proceeding is required because without this misconduct, you cannot go for a departmental proceeding. Can you go for the departmental proceeding?
No, we cannot go, but because that appointment is illegal, we have given
and we may notice and whatever
natural justice
challenge your decision.
Well,
it is not his misconduct.
Well, only to meet the natural justice, we have
this.
You have a book.
In Local Act Volume 2, Local Act Volume 2 रे देखते हो तारिक Local Act Volume 2 or 3 P. Volume 2 का Volume 2. Page 859 of that Volume 2.
Yes. No. I was saying. Yes. Now this under your rule 15.
Hello.
There is an equivalent rule of rule 14 of the CCS rules.
Central Melody.
There should be allegations forming charge.
Melody.
And then only you can embark upon the inquiry.
Melody.
What is the allegation against him?
In fact, I have seen that memorandum of charges. So the employer has committed mistake, no doubt the employer has committed a mistake. And instead of terminating directly by giving a so-called notice, we have initiated a departmental proceeding under Rule 15. That is the fault with the government. It should have been terminated by issuing only formal.
So what is the purpose of this inquiry?
Only to find out whether any fault has committed by him. To arrive at the truth of the matter, that allegations level.
You read
Hello.
From the chart, then you will understand this is not the purpose. This third paragraph of the first charge. The above irregularities done by you attracts the disciplinary action as per such and such. I am asking what irregularity in the circumstances he has done.
I am submitting that he has not committed any irregularity. The
After
employer,
the proceeding can be permitted.
yes, the employer has committed the irregularity in giving him appointment after the cut-off date. That is the admitted fact. So, madam, I am submitting the.
So whatever decision you will take on the basis of that, the appointment, and you have done this, irregularity is done by you, attract disciplinary action.
Madam.
So if there is no irregularity, so there is no question of disciplinary action according to you.
Well, in fact, no disciplinary proceedings should have been initiated against him.
Exactly so. So we are quashing it. We are giving liberty to take appropriate action.
Yes, madam.
Affording any opportunity if any action adverse.
Yes, madam. Yes, madam.
No, there is no question. You just were coercing.
Yes, madam.
Is already retired.
Yes, madam. You also make
Forget about things.
by giving us opportunity.
No. He has retired already.
From the year 2013.
Because
what action you will take against such a person?
And your lordship, I'll take only.
If we will hold that his appointment is illegal, then he will not get the consequential benefits, my lord. The consequential benefits like pension and other benefits, even if he has retired.
Yes.
Suppose we will hold that his appointment is illegal.
Yes.
Then he will not get any consequential benefits.
And after how many years he can start fresh?
Because of this, he has approached the Learning Tribunal and has got the interim order. Because of this interim protection, he's continued and he retired.
Yes.
So while disposing
retired in 2013,
and that matter is of the back in 2012.
Yes.
So before his retirement, he has approached the tribunal, and by virtue of interim order, he continued.
So,
if the very appointment is illegal, he cannot get any benefit.
Benefit? Are you sure?
Yes, madam.
What about the labor that he has put in all these years?
He has got the salary for that period. He has got the salary. That I am saying, if very appointment is illegal, so he has worked and he has paid his salary.
Yes, right. But why have you not cancelled it so long?
I said that proceeding was initiated. That wrongly that proceeding has initiated.
The stay order was against the proceeding.
Yes, my lord.
Not that your hands were not tied to pass an appropriate order, taking leave from the court or.
Yes, my lord.
It's not done.
May I interrupt only one thing? Now I am coming to the merit of the case. Whether the allegation made against me that I was given appointment during ban period. Ban period, your lordship, that was in court 17th April 1993. I draw your lordship's attention to Annexure 2 of the writ petition.
Yes.
Your lordship, kindly see your lordship that it page Annexure 2 of the writ petition. That is your lordship will see. That is gradation list prepared by my employer. Did my lordship get it? Annexure 2 of the writ petition, your lordship.
Mr. Mahanti, the difficulty is that you got it stayed. You should have, you should have participated and simply the answer listen when you cannot follow. So now, as lordship, as it fell from my lord, that those filing of those three original applications cannot be misconduct.
My lord.
But as far as your date of appointment is concerned, you could have simply brought to the notice of the authority that I was appointed prior to 17/5.
77.
Whatever it looks, the date is prior to the cutoff. So, but you did not avail that opportunity.
Because your lordship, why your lordship? That is also I put to this question to me. Because my appellate
just to give the dates.
My lord.
When the ban was imposed.
My lord, ban was imposed, your lordship will see. That is as per the
1993.
Huh?
12/4/1993.
And you were appointed?
My lord, I was appointed, your lordship will see. That is, your lordship will see Annexure 6 where they have in their so called they have stated. That is in the year 1977. Your lordship.
Oh, give the date.
My
Who won 1977?
My lord. That is 3/1/1997. And there is one number of given, that is SR number 141 of 1977 by the Deputy Director, Baleshwar, Consolidation Officer Circle.
Yes, Mr. Kuntia.
My lord, I have seen. My lord, your lordship may give me one opportunity. I'll verify if the appointment is 1970, what he has stated, 3/1/1977. So that
You may not go to his version also. You take annexure 3 of the petition, page 14. That is your letter. Could you get that? 14/9/98.
Yes, ma'am.
KK camp, that Roman, small Roman 2. The service particulars of the applicant under the settlement officer Kotak is mentioned as below. So even your letter starts at 5488. Intermittently, of course, intermittently. And please mark the last paragraph. The total length of service was 5 years, 10 months, 6 days, as on 13/9/94.
Yes, ma'am. That last is even if with 26.
So don't take 77.
Yes, ma'am.
Don't take 77.
Yes, ma'am. Even if it is accepted 26/2/1992, that is prior to
So you take 94 also. By that time, he had completed 5 years, 10 months, 6 days.
Even if it is taken as continuous service from 26/2/1992, that is prior to 12/4/1993.
So he is actually working for a long time. There is no question of appointing him after the ban period.
Unless they mean something else, like they have written something words and
Yes, Mr. Kuntia.
My lord. Hello, your lordship, turn to page 81.
Is your affidavit?
In the writ appeal, ma'am. Yes, my lord, this is our affidavit, reply affidavit on behalf of property part number 3.
Yes.
The petition was relieved from settlement office by the office order number 27/6/1994 following reduction of work disengagement order. That the applicant Behra was again engaged in settlement office on 25/1995. So he was retained on 27/6/1994. So that fresh appointment was 25/5/1995. 1995.
What about the other people you have appointed along with him in the gradation list?
Those who have continued, they have been brought over to the regular establishment or they are allowed to continue. Because of what I find from my reply, because of the reduction work, he was retraced. It is the admitted fact in 1990.
Lordship's query is very simple. All these persons, they were engaged intermittently in different camps. And in fact, you have noticed that also. I mean, rather fairly you have stated in that table at page 80.
Yes, that
so that is the background of all the persons.
So others, I cannot say that.
You can mark that also.
Yes, my. What has happened to others?
That detailed chart is there. Yes. Which page?
That is your lordship.
That is in the WPC OAC.
That in the rejoinder he has.
He was never regularized.
Yes, man.
I was regularized and given retirement when I was a regular government servant. Now I am also getting minimum pension.
Now, where he was regularized?
He has not been regularized.
Regularized.
Has been regularized.
Then?
If he has been regularized, you will also may dispose upon merit. But this is the fact because why you are saying that his appointment is after 1912.
Where is the order of regularization, my lord?
Annexure 5, page 18. Page 18 of the OAC, WPC OAC, 1-8, Annexure 5. Mark the fifth line. Under regular, this job contract amends of different settlement wings sponsored by Board of Revenue, Odisha Cuttack from the revised common gradation list are appointed as amins, munserims under regular establishment.
July 2013, that is our given retirement.
Lordship is correct that he was regularized in 2000. Subsequently, when it came to the notice of the government, his appointment is after cut-off date and he has been regularized. That cause of action arose in 2011. Your Lordship can find it from page 45. Admitted fact, he was regularized in 2000. Subsequently, it came to the notice, his appointment was after the cut-off date. So, in 2011, your Lordship can find it page 45.
Actually,
this is admitted fact, he was regularized.
No, you are saying that his last phase of appointment is post the ban order.
Yes, my lord.
That is the problem.
Yes,
at best that can be your allegation.
Yes,
but that is not his first appointment.
That is not his, because he was
see all these persons. Just take page 19. Well, after page 18, page 19. The serial number 1 up to 25.
Well,
then Amin starts at serial number 1. Dayanidhi, this petitioner is also Amin.
Yes, ma'am.
You see, it starts at the serial number 126. Could you get it? Page 19, last line. Page 19 of the petition, WPC OAC.
Dayanidhi, serial number 1 in respect of SC.
126, then Dhaneshwar, 142. Then SCBC. It starts with some barik. It's not visible.
Some barik.
Right. So, the petitioner is at serial number 561. So your statement at best could be that his last phase of appointment was post.
Yes, that I am submitting.
So how can that be in view of all these persons?
If my lord, they have not.
Then his serial number could not have been at serial number 61.
Yes, my lord.
His submit list goes up to serial number 133.
I got my lord's plan. Because if his serial number 133 has been regularized and he has been appointed after that person.
Yes.
Not only the regularization, not after the post 95 appointment. I think that for purpose of regularization, all the past years of his engagement are taken into consideration.
Maybe that I cannot submit to that extent.
It's obvious.
Well, I mean,
It is apparent. Apparent because it is apparent that if 133 is regularly admitted fact, obviously that 61 is prior to the date of appointment of 133.
Yes.
This is the gradation seniority list. So what has happened to other persons that I cannot submit?
No, that you should not submit. It's a gradation list.
Not gradation, that gradation list is not there, but you also can find it the just right side, that number is given, perhaps that is the position in the gradation list. Page 31, you also can see from page 31.
His name is
page 32.
Prashant Kumar Bhaiya.
Nadia Chand Bhaira.
Bhaiya.
Well, he has been placed at serial number 61, taking into account his last service period. That has been clearly mentioned. You also can find it page 36.
So we don't think that your action is proper. We are passing the order. Moreover, this person is now retired. He's worked all these years and he had no complaint about his work. Only these 95, and before that he's working and it is on record. You have brought in on record.
That past service has been taken into account.
Obviously, it has been taken into account because someone only after 5 years of service cannot be regularized. Otherwise, show that on the basis of the 5 years of service, he was regularized.
Yes, ma'am. That shows, because if 95 will be taken.
That is why I'm telling you that cannot be.
You also can find it from page 36.
36 is the 36 of the writ appeal?
Writ appeal, ma'am. For that reason, has been placed at serial number 61. Otherwise, his position would be different.
It was earlier 88.
No, he'll also place that.
For regulation, that is you have mentioned that for regularization, his serial number was at 88.
That has been revised.
Post regularization is 61.
That has been.
You are referring to
page 36
of the writ petition.
Writ appeal, my lord.
Yes. 36 additional secretary's order.
Yes, ma'am. And this is so cause filed before the tribunal.
So that is, suppose the petition has caused.
Yes, my lord.
Thank you. You are Mr. Biswal? Sanjeev Mohanty, sorry. Learned Sanjeev Mohanty, learned counsel, appearing for the appellant. Also heard Mr. M.K. Khuntia, learned regional government advocate. By means of this intercourt appeal, the order dated 17th July 2023, passed by the learned single judge in WPC OAC number 48 of 2012, has been challenged. Stop. Learned single judge by the said order dated 17th July 2023 has observed for purpose of disposal as follows. Judgment 6.2, page 93. 73 or 93? 93. Quote 6.2. Since the petitioner had challenged the very initiation of the proceeding and an interim order has been passed in his favor, this court permits the petitioner to file his written statement of defense within a period of 6 weeks from the date of receipt of this order. If such a written statement of defense is filed within the aforesaid time period, the opposite party number 3 shall accept the same and proceed with the matter in accordance with the law and dispose of the proceeding as expeditiously as possible, preferably within a period of 6 months from the date of filing of written statement of defense, if there is no other legal impediment, unquote. Stop. Mr. Mohanty, learned counsel, has submitted that by means of the writ petition, which was formally registered as original application in the state, the Orissa, this, what is the
Administrative Tribunal. Orissa Administrative
Tribunal. Stop. The petitioner had challenged primarily the memorandum of charge dated 29/12/2011, annexure 12 to the writ petition. Stop. The charge is proposed for purpose of departmental action are as follows. Page 36 of the writ petition. Sri Nadia Chandra Behera, Chand Behera, Nadia Chand Behera, Amin of
Kotak Major Settlement,
Kotak, now working at record office. Record officer?
Recess office, Your Lordship. That is.
Recess office, Kotak, is hereby directed to explain as to why his first JC appointment order in the post of Amin will not be cancelled, which was issued to him by the office order number 5698 dated 20th May. May or March?
May, Your Lordship,
May 1995. After imposition of strict then order on appointment in NMR/ILB/work chest and job contract by Finance Department Circular number 17815/F-stop dated
17, Your Lordship, 17
April
1993.
1993. Stop. The said appointment is purely illegal and unlawful. Stop. It has been imputed that the petitioner imputed that the irregularities have been done by the petitioner, appellant, and he has been liable to disciplinary reaction as per the provisions of OCS and CCA Rule 1966.
62,
yes, 62. So he has been charged as follows. One, role is suspicious as he has suppressed the fact for self-interest. Two, misconduct. Three, malafide intention for self-interest. Stop. It has been further imputed that the petitioner, by approaching the state administrative tribunal, by filing original application oftentimes, he had sought to reap undue financial benefit, which is illegal.
Dues. Illegal dues.
Reap benefits, which is illegal dues and malafide intentions to create imbalanced situation to the authority. Stop. Mr. Mohanty Learned Council has emphatically submitted that for purpose, and submitted that any of the charges as proposed cannot lie in the given facts and circumstances. It says the charge memo, Annexure 12 to the writ petition is liable to be set aside by fully exonerating the appellant with regard to the writ petitioner. Stop. There is no dispute that on 12/4/1993, 12/4 order is not here. Well, for 1993, the state government imposed total ban on appointment of any person on work just establishment. Despite that, by the order dated 20th May 1995, Annexure 13 to the writ petition. This is not the order. What is your appointment letter?
Your Lordship, regular appointment?
No, contingent appointment.
That is. It is on your lordship will see 3/1/1997. The paragraph I have heard, they are not disputing.
No, it is a 95, Mr. Frontier.
Yes, Malik.
Where is that 95?
Why is 95? Your lordship can find it from page 81. Yes, Malik.
Eighty.
And page 84 is the appointment order of 1995.
Is 80.
84, my lord.
What is the last line you have taken?
Any person who wants to discuss in this paper, and the other
Something annexure. This is a part of annexure 14.
Yes, my lord.
14.
It starts annexure 5. It has been stated annexure page 78. It starts page 78. That is the reply affidavit on behalf of opposite party number 3 to the rejoinder filed by the petitioner. Annexure 5 to the writ of appeal.
Annexure A by 03 of the reply affidavit filed with the opposite party numbers 3 in response to the rejoinder filed by the petitioner in WPC OSC number 48 of 2012. By the said order dated 25/1995, the petitioner was appointed
The inspector, that is a promotional post.
as Inspector Grade 3 and posted to the recess of his Cuttack stuff. The petitioner was thereafter regularly appointed
Annexure 5 of the writ petition.
Page 30.
Regularly appointed by the order dated 16 September 2000 and issue 5 to the writ petition. In the scale of pay of rupees 2,750-4,400 with other usual admissible allowances. Stop. By the memorandum dated 29/12/2011, Annexure 12 to the writ petition The petitioner was supplied with the imputation of charges as noted above. Immediately the petitioner challenged the said memorandum and obtained an interim order which continued till the order dated 17/7/2023, annexure 7 to the writ appeal was passed. Stop. Mr. Khuntial, an additional government advocate, has stated that by virtue of the interim order, petitioner continued in his service and finally he has retired from the service in, can you give them?
Annexure 5, page 18 of the repetition.
Yes, my lord, your lordship, see that I am there showing that appointment order was regularized of me, but he was appointed in 1995 as a inspector grade 3.
There is a promotional process.
So that cannot be said that it's a continuous process.
No,
It's very
no, Mr. Khutia, lordship was asking about page 85.
Yes.
And why does it refer to job contract?
Where inspector grade 3 is hereby
No, that ban order, 12/4/93 ban order.
Yes.
Which is the basis of your submission or your, the contention of the authority that it was illegal. So why does it ban appointment in job contract?
Your lordship, ban on work charge employees and NMR and ban on engaging person, daily wage personal response on engaging on a
refers to job contract.
No, the job contract, but this is not, your lordship, that page 84. He's also not appointed on job contract.
No, that is not his regulation order.
That is not his regulation.
That regulation order is different.
Yes, my
regulation
as if he has been appointed as a job contract.
Regulation, that earlier order.
Yes, the job contract
in
in
page 18 or something. That is page 18 of the writ petition.
Admitted fact, he appointed a job contract in 1987 on spell.
So suppose you say that his appointment is illegal, 12/4/93 ban order doesn't help you.
Your lordship, that 95 happened. Why I am saying that is helpful for 93 Your Lordship, 95 appointment, he is not appointed on job contract basis.
No, that is, you see, you look at the imputation.
But charge, that I have seen that. So
then why you are now
imposition of the proceeding and that I've seen that memorandum charge, that is not permissible.
12,490
Because one
you are
highlight case
saying
before the
that this
tribunal
appointment is illegal.
Yes, ma'am.
Well, what is the date of the superannuation when he retired?
That is, your lordship,
31/7/2013.
31/7/2013. According to Mr. Panthia, the petitioner's regular appointment, the appellant's regular appointment as the Amin is illegal as the same was issued in defiance to the said order dated 12/4/1993. On scrutiny of the said order, we find that the said order is in respect of only engagement under the work charge establishment. So, as such, for appointment is in the regular establishment, the said ban order cannot have any application. Even the respondents did not raise any objection regarding the mode of employment. But from the records, it appears on umpteen times the appellant had worked in different capacities to the Settlement and Consolidation Department, Government of Orissa. Stop. From the counter affidavit filed by the respondents, we cannot find any material placed that at any point of time any sort of allegation has been raised against the appellant in the writ petitioner that he influenced or he has forced any document to get such employment. Stop. On the contrary, from the this here shows from the 36, not that part. This they are replying. 36. This page 36. That statement is which page 36?
36, your lordship. There is additional secretary to.
Texas of which writ appeal or writ petition?
That is the writ petition, your lordship will see. That is annexure 6. Annexure 6 of the writ petition. And that is annexure 6 of the writ petition.
For the reply filed by the respondent number 2.
My lord. Your lordship.
The Director Land Record and Surveys Orissa.
Next page, your lordship will see.
Filed in contempt petition number 176. Within bracket C 2000, arising out of original application number 3523 within first bracket C / 2000. It has been stated as follows. It is humbly stated that the opposite parties have not intentionally deleted the name of the applicant from the gradation list. Rather, the name of the applicant has been placed on serial number 88, taking into account the past service period of consolidation and settlement organizations under JC settlement, after which he has been absorbed in the regular establishment. So, therefore, the petitioner's absorption is based on the was also is based on his past service. So in the counter affidavit filed by the respondent number 3, the petitioner's engagement statements are available. Before his appointment as the inspector, grade 3 in the recess of his quarter on 25/1995. Petitioner had worked since 2001 to 2nd January 1997 to 11th July 1994 in different spells with breaks. Stop. And his service during that time was, according to the record, was unblemished. Stop. It has been further pointed out by Mr. Mohanty, learned counsel for the appellant, that not only the petitioner was absorbed in the regular establishment, but others of holding the similar nature of job, were also absorbed, but no action has been taken against any one of them. Be that as it may, after appreciating the record and the submission advanced by the learned counsel, we are concerned with only 3 questions for disposal of this writ petition. Those questions are: 1, whether the the appellant, within bracket the writ petitioner, can be imputed for the misconduct to whether the order of appointment dated 8. What is the 2000 order date? 3.
That is the regular appointment. That is the
31.
18 Royal Lordship will see Annexure 5 of the writ petition.
16 September 2000 is illegal or not? So the question relating to the 3. 3, whether the petitioner can now be terminated for so-called appointment, terminated on the ground that his appointment in the post of Amin, wide order dated 16/9/2000, was against the ban order. Stop. So the first question is concerned. We find there is no material against the petitioner to impute him for misconduct. Stop. Even if we assume that the petitioner was irregularly appointed, the petitioner cannot be held responsible for such appointment. So for the imputation of approaching the state administrative tribunal is concerned, for redress, such action of the petitioner flows from the constitutional right, and hence that cannot be stated to be an imputation against the petitioner. So tenable imputation against the petitioner. As a result, we set aside the memorandum dated 29th December 2011, Annexure 12 to the writ petition. But since we have held that the no imputation has been made out against the petitioner, no action on the said memorandum dated 29/12/2011 can be taken against the petitioner. What is the second question? Stop. We have also examined the letter of appointment dated 16 September 2000, Annexure 5 to the writ petition. So, even the respondents have not stated the said mode of appointment is irregular. Their only complaint is that petitioner was appointed after the ban order, which was reiterated on by the memorandum dated 12th April 1993.
So, we have examined the said ban orders, and it only applies to engagement to the work charged establishment. It is nothing, NMR and work charged
And DLR.
And NMR, DLR and work charged establishment. For the absorption of the petitioners is a substantive appointment to the regular establishment. Therefore, said appointment cannot be hit by the said circular. Even if some regular appointments can be regularized, irregular appointments also can be regularized by the employers. So we have seen the petitioner, the appellant was working under the on different spells under the settlement in the consolidation department, and that was a long period, more than 22 years with breaks.
No, my 5.
It was 77 to 19.
Not 88. 88. 5 for 88 till 94. Let's you can find the different dates.
I'm saying with breaks.
Yes, ma'am. From 88 to 94 with breaks.
No, there are several breaks.
77
is there.
77 is there, and it is your counter.
In the counter page 80, that we have stated the different spells.
That is why I'm saying the different
counter page 48. Counter in the OA, this OA, not the earlier one.
Yes, yes.
OA 48, kindly check. Counter by respondent number 3. It starts with Mathani camp in Balasore.
2nd January 1977.
2nd January 1990.
Yes.
No, it is 1977.
77, yes. 2nd January 1977.
Yes, ma'am.
So, in our concern, so for the third question is concerned, in our considered view, that since there is no illegality in the appointment of the petition, as per our considered view, no action to say list of the termination can be taken against the petitioner. In the result, having observed this, we set aside the impugned order dated 17/7/2023, Annexure 7, the writ appeal. The result, the appeal therefore is allowed. No order is to cost. Next. Tomorrow we'll list other matters. Other matters will come tomorrow.
Item number 1.
There are two appeals. CRLA 455/2018 in respect of Bimor Kumar Khetan, his husband. He has been convicted under section 490A, 304B, 302. Husband. He has been convicted under section 490A. There are four appellants. Kailas is the father-in-law, Kanta Devi is the mother-in-law, Sunil is the brother-in-law, and Sujata is the sister-in-law. And in the meantime, Kailas has expired. So against Kailas, appeal is abated.
Kanta Devi's mother, Sunil Kumar is
Kanta Devi. And Sunil is the elder brother-in-law. And Sujata is the sister-in-law. The wife of Sunil. Pedal 5 and Pedal 19 is both are doctors. They have conducted postmortem examination. They have specifically opined this is a case of cardiac arrest, which is a natural death. Pedal 5 and Pedal 19. There are two dates. Two dates are important. Marriage was taken place on 9/5/2005. Mala kindly marked it. 9/5/2005. And death was occurred on 1/10/2005. Within 4 months and 21 days. And kindly, my lord, see the paper book.
But you said on that day, postmortem report, as per postmortem report, the opinion was reserved.
Yes. Outing viscera. The IO did not, after receipt of viscera, IO did not produce the viscera report before the Schedule 5 and 19 for his opinion. Now we'll also kindly see the circumstances under which the land trial court has come to a finding. This is a case of 304B and 302. The first of all, there cannot be modes of conviction is totally different in respect of 304B is concerned and 302 is concerned. Entire case, there is no case of homicidal death. There is no finding, there is no eyewitness to the occurrence. Totally based on circumstantial evidence. Now, what are the circumstances land trial court has relied upon? You will also kindly see the page, the para 22 of the improved judgment. The page starts from 61. Page 61. Yes. Well, I got it. May place, because there is no direct evidence in this case that the accused persons committed murder of the deceased. The entire case of the prosecution is based upon the circumstantial evidence. The prosecution has already proved one of such circumstances that the deceased was subjected to cruelty and dowry torture soon before her unnatural death in her in-law's house, in the house of the accused person. The other circumstances, according to the prosecution, are the deceased was sleeping with her husband, accused Bimala, at the time of her death. This part of evidence is not available in record. None of the prosecution witnesses have whispered about this fact that deceased was sleeping with the appellant. This part of evidence is not in record. Where from the trial court got it, I don't know. The deceased was sleeping with her husband, accused Bimala at the time of death. Thereafter, soon before her death, the accused Bimala supplied a glass of water to the deceased. This is also not available on record. After registration of UD case at my behest, the UD case was registered on my behest. I immediately went to the police station and reported the facts on the very early morning. On the basis of my report, UD case was registered against the accused person absconded. False plea have been taken to cover up the absconding. There is no question of absconding because I was arrested on 3rd. Occurrence on 1st, I arrested on 3rd. The accused person till date have not disclosed about the cause of death, except supporting the casual opinion of the doctor that the deceased died due to sudden cardiac arrest. Malad, these are the circumstances when trial court has convicted Bimal Khetan under section 492, 304B, 302, 406 and 4 DP Act. So Lordship, kindly see the question put to me in 313 statement, question number 27. So Lordship, kindly see page 90.
Question number 27.
Mala.
Yes.
It transferred from the evidence. Mala got it. It transfers from evidence of Dr. Arun Kumar Das, PW5, and Dr. Salasunki George, PW19, that they have conducted postmortem
examination. It transfers from the evidence.
Yes. It transfers from the evidence, Mala. It transfers from the evidence of Dr. Arun Kumar Das, PW5, and Dr. Salwanti Jojo, PW19, that they conducted postmortem over the dead body of the deceased, Monisha alias Muskan Khetan, and submitted postmortem report, Exhibit 4, and according to them, the cause of death of deceased was due to sudden cardiac arrest. What you say? Yes, this is the fact. Once this question was put to accused in 313, PW5 and PW19, with regard to opinion given by PW5 and 19, and the accused said, yes, this is the fact. The doctor has opened, this is a clear case of cardiac arrest, natural death. So, when trial court, without examining evidence of PW5 and 19, he has substituted his opinion. My Lord knows that 92 Supreme Court, page 218C, 2186, Mafabhai Nagabhai Rabhal case, where the Honorable Supreme Court has said, if the medical evidence is inherently defective, then only court has power to substitute his opinion. My Lord knows that leading decision of that. Now the vital question is PW5 and 19. If my Lord PW5 and 19 will be disbelieved, their evidence, doctor's evidence will be disbelieved, then only 302 or 304B will come to picture. If kindly see the evidence of PW5, my Lord, PW5 evidence starts from page 107 of the paper book. My Lord, got it?
Yes.
My Lord, the age of the deceased is 22 years. She average built, rigor mortis present, both upper and lower lips present, and absent in neck, then dried blood mixed with the present on both nostrils and mouth. My lord, mark it. No external injury found on the body. On dissection, thorax cavity and lungs and heart were intact, normal and congested. Left ventricle of heart was empty and dried contains few amount of blood. Organ of abdominal cavity were in the intact, normal and congested. Stomach contains 200 cc of colorless fluid. Small intestine also contains colorless fluid. Large intestine contains physical materials. Urinary bladder contains 50 cc of urine. Uterus is normal size. Brain and spinal cord were intact. Viscera is preserved. Lungs, heart, liver, kidney, and spleen, stomach, and its contents. Small intestine is presenting concentrated and common salt. The report was prepared, silent Jojo. I have signed on it. Exhibit 4 is our report. Exhibit 4 is my signature. The postmortem report was written by Jojo. Exhibit 4 by 2 is signature. Exhibit 4 postmortem and Exhibit 4 by 2 are prepared by my presence, in my presence. So let's kindly see cross-examination. I advise the accused persons to report the date of deceased to police because he attended the deceased first. Accordingly, he advised the accused person to report the matter to the police, and accordingly, it was reported. We did not find any external or internal injury on the body of the deceased. Absence of such injury relies application of force, reserve the opinion outing to chemical examination report of viscera to ascertain about poisoning or not. Police has not called for any further report from us after received viscera report. On perusal of chemical examination report of the viscera, I do not find if it is a case of poisoning. So also the chemical examination report of vomiting, I do not find poison substance. Going through the postmortem report and chemical examination report, I find the case of poisoning is ruled out. In my opinion, after perusal of the postmortem report, the death was due to cardiac arrest, cardiology, and stroke. There are instances of a healthy young persons dying due to cardiac. The death due to cardiac is called cardiac death. One can die within 1 hour of onset of symptoms of the various causes of cardiac may are not detected in the postmortem report. There may be a vomiting in cardiac arrest, cardiac arrest. Vomiting also occurs in case of heredity, hypersedity, gastro disorder, and other causes. Death due to cardiac arrest in a natural death. The specific opinion has come, death due to cardiac arrest is a natural death. Thereafter, what happened, the PP filed a petition to declare him as a hostile witness. And he was cross-examined and he has given all the answer put by the PP. And one answer you also can see that question number 7, page 1110. Answer regarding sudden cardiac death, question was put. Regarding sudden death, can you give a single instance that a lady of sound health at the age of 22 years has died of cardiac arrest in India? Or have you come across such a case in your experience in medical science? Answer is, I have come across few such cases of cardiac lady of that age in India with sound heart, but I cannot give particulars of those cases. This is the answer given by the doctor. Now, trial court, basis of this, since he failed to explain or he failed to disclose the cases, he disbelieved the evidence of Idulfa. Now you also kindly see next page 111, cross-examination by defense. This is more important, is page number 111. In this case, death of deceased was due to sudden cardiac arrest. There may be
cardiac arrest without infection or thrombosis of heart, even in healthy heart condition in case of young lady. I am medicine specialist and cardiology is a part of the medicines. I am treating cardiac patients since last 30 years. I am come across in some cases that young person died of cardiac arrest in healthy heart, and I do not remember the particulars of those cases, but records made available in the hospital. All sleeping pills are poisonous drugs. All drugs are poisonous. If viscera is collected within 24 hours of death due to overdose of sleeping pills, then most likely the presence of poisoning during poisonous be detected in viscera chemical examination. In this case, viscera was collected within 12 hours from the date of disease, so the chance of death due to intaking of sleeping pills is very remote because no drug is detected in the chemical examination of viscera. If the mouth and nostril be gagged in soft pillow, she dies, that will be asphyxia death, and in that case, there will be congestion of lungs and deposit of water in the lung. In the present, there was no congestion of lungs and there is no deposit water, so asphyxia death is completely ruled out in this case. There may be a mark of struggle while gagging the mouth of nostril if a sleeping person awake. In the present case, I did not find any mark of violence on the body of the deceased. In case of gagging, hairs of clothing will be noticed in the mouth and nostril of the victim. But nothing of that sort is noticed in this case. If the mouth and nostril gagged by soft pillow, mark the lips will be there on the pillow. In this case, I visited the deceased and found her death in between 5:30 to 6:30 am, but I did not find suspicious circumstances suggesting foul play. As deceased died within 7 years of marriage and she is a young lady, I suggested her husband and others to inform the matter to police about the death. Taking all the factors of my examination, I am of opinion that death of deceased was due to sudden cardiac arrest. There are more than 30 causes of heart attack, about 50% of structural causes, and rest are functional cases. In some cases, heart attack due to structural causes, positive evidence is not available in the postmortem. Same is case with cardiac arrest due to functional causes. So one has to conclude, taking into consideration different examination of patient in cardiac arrest. The textbook of Parekh is the authority of the subject. According to Parekh, the doctor has to wait for report of chemical examination before giving a report on postmortem examination out a report of chemical examination. In this case, when I felt necessity of chemical examination report of viscera, I opted for that and did not give my opinion on postmortem examination. The IO has also not obtained my opinion after receipt of chemical examination report. Death caused by cardiac arrest or natural death. In this case, it is a natural death. The same evidence is available in respect PW 19 also. If my lord will find PW 19, PW 19 is page 153. At page 153, PW
Similar vein.
My lord.
She has stated similar to this PW.
Yes, this is similar view has been given by the PW 19. Now the LOC can see though there is a specific evidence brought out on record, this is a clear case of cardiac arrest, sudden death. You also can see how the medical evidence has been disbelieved by the trial court. You also can see para 12 of the judgment. Para 12, page 49. Malagati.
Yes.
That my lord may read the
relevant part only you can read.
Yes, the relevant part, my lord, you also will find
that was page 51. Page 51.
Yes.
The ninth line. Therefore, at no stretch of imagination, my lord got 1, 2, 3, 4, 5, 6, 7, 8. Ninth line from the top starts from therefore at no stretch of imagination. To have set up goals, 20 as per their dowry demand before marriage and other demands were fulfilled at the time of marriage. 4 days after the marriage, the deceased and father-in-law demanded further dowry from me over telephone. This part is not available in the affair. At that time, they demanded further dowry, 1 diamond set, further 2 lakhs cash and 50 tola of gold. Repeatedly, we are getting such phone calls. The deceased also complained before me for apprehension of torture upon her by her in-laws and husband on non-fulfillment of further demand of dowry while she was visiting us at Teklaga. This was also not available in the alleged affair. I consulted my daughter that time in help of everything, and I am trying my level best to fulfill their demand in due course. On dated 2/10/2005, at the morning, I got further telephone from the house of laborers of the house of in-laws of deceased that the deceased is dead. So this is also not available in the affair. Sankarlal Khetan informed me about the death. Thereafter, I, along with my relative, came to Jharsuguda. I reached at Jharsuguda at 4 p.m. on the date of occurrence. Going to the in-laws house of the deceased, I found she was lying dead in the bedroom of Akil Khetan. We suspected that it is a case of dowry death. At that time, I did not find anybody in the house of in-laws of the deceased except her father-in-law, who also left the house a few minutes thereafter. Thereafter, I went to Jharsuguda PS. I lost the affair. When at about 5:30 p.m., I went to PS to lodge the affair. Police did not receive the affair, saying to aid in cremation of the deceased. Thereafter, the police received the affair at 11:30 p.m. In the night of the date of occurrence, I told the criminal, Exhibit 5 is the said affair, Exhibit 5/1 is my signature. But before this, police conducted inquest over the dead body in our in-laws house at 3 p.m. in my presence and in presence of my relatives and cousins of my son-in-law, whose name I do not know. After the inquest, the police prepared inquest report in our presence, and after the contents of it read over and explained to us, we put our signature. Exhibit 1/2 is my signature in the inquest report. I have made the endorsement in column 9 in the inquest report that it is a case of dowry death. We requested the police to hold postmortem at Burla and not at Jharsuguda, but the police declined to accept our proposal, saying that facility of postmortem is available at the district headquarters at Jharsuguda. Police seized the marriage invitation card and marriage photograph on my production under schedule list, Exhibit 6 and 61 in my signature. The cross-examination can see. I do not know if the entire process of inquest and postmortem were videographed. Though several police officers were present at the time of inquest and postmortem, I do not know their designation, whether amongst them were the CI and the SDPO. I cannot identify or name the police officer who conducted inquest. I also cannot say the designation and rank of police officer. Sankarlal Khetan, who informed me about the occurrence, I do not know if he is the elder brother of accused Kailash Khetan. Again says, Sankarlal Khetan is the brother of accused Kailash Khetan. I had gone to the house of the accused Kailash once between 1 to 2 months after the marriage of the deceased. Kailash Khetan accused has got his godown and office at the ground floor and residence at the first floor. We reached at Jharsuguda in between 2 to 3:30 p.m.
That's very material facts you are reading out. You show that he stated, I stated to the police, where your contradiction.
That will also can see evidence of PW 21.
No, he has also.
He is. You are bound to.
121, page 120.
If you say that you have to record the omission.
Where is 161 and FIR has been confronted to him?
Yes.
My lord, to kindly see page 121.
Yes.
121, my lords. Uh, 16th line. I have not mentioned, this is 17.
Yes.
I have not mentioned in the affair that accused demanded home appliances or that we gave. I have also not stated in the affair or before the police in 161 statement that I gave cash of rupees 2 lakhs as per their demand before the marriage. As payment of dowry is an offence in law, I did not mention in the affair or not stated before the police that accused person demanded gold ornaments named in chief other than cash and home appliances, and that will fulfill the same at the time of marriage. It is not a fact that I have not stated, my lord, before the IO or that IO have gave 4 days in the marriage. The decision the accused Kolas demanded for the dowry will set. So, lordship, kindly see the evidence of Schedule 1 confrontation. That part, my lord, will see. With IO.
Do you think this is the procedure that has been followed by the defense is a correct procedure to record the omission or contradiction? Is it a correct procedure? One thing, when he admits, there is no question of further contradiction.
Yes.
Because he admits.
Yes.
Right, that's there. But when he said, no, I have stated to the police officer. I have stated to the police officer.
Oh, this part of it, I'm not touching that. Where the plot he has said, in her evidence he has stated that there was demand after marriage there was demand. That part of evidence in his statement, in his examination, he has stated that I have stated before the police. That he denied in his cross examination. But what P.D. 21 I has stated, that I want to see your lordships.
I was no witness. Lord Counsel, with all honor to you, and IU is not a witness of these things. First of all, whether he has stated or not, the primary basis is the statement that is recorded in the section 161.
Yes.
Or the first information report.
Yes.
These two documents is available to you for contradicting whether he has or whether he has stated to the police officer or not.
Yes, sir. Correct.
Procedure first put the question. He say yes or no. If he says yes, I have told to the IU, then you show the very document to him. Where is that document was shown to him?
That's not.
I have gone through the entire statement. There is no such effort.
But he has admitted, my lord, that I read that. I have not mentioned in the affair. Yes, that is.
Admitted part, there is no.
Yes, that he has admitted.
This admits who are we.
Yes, I have neither I have mentioned in the affair nor I have stated in 161 that he has admitted that. But they have not confronted the 161 and as well as only affair, contents of affair as well as 161. But he has stated this part of evidence or not at the time of 161.
Part is admitted. There is no question of confronting also.
Yes, yes.
Only when he said, no, I stated to the police, then you have to show the document.
161.
Whether just see whether have you stated to the police. This is the statement recorded by the police. He even thereafter can say, no, I stated to the police, but police did not record the status. Then he go revert back to the investigating officer.
Yes.
Page 175. Para 30. Para 30, page 175.
Yes, para 30. May I place para 30, page 175? May I please? Yes. In this case, prosecution case of demand of dowry is only after marriage, that is 3 to 4 days after the marriage. It is a fact that PW6 Gajanan Agrawal has not stated before me, either in affair or in his statement under section 161 CRPC before me, that the accused persons demanded rupees 2 lakhs, 1 full set of gold, 1 half set of gold, 25 pairs of earring and other home appliances. He has stated in his statement under section 161 CRPC before me that whatever he had given, he was given in Kanyadan. It is a fact that PW6 has not stated before me anything regarding accused Kailash, Kanta Devi, Sunil and Sujata at the time of giving his statement before me in the case. It is also a fact that PW6 has not stated before me that before the marriage, accused demanded dowry of rupees 2 lakhs gold ornaments and he has paid them as per demand. He has also not stated that the deceased coming to their house reported about any demand and for apprehension of torture. It is not mentioned regarding giving home appliance in the affair or in his 161 CRPC statement. He has also not stated before me that 4 days after the occurrence, accused Kailash demanded dowry through telephone, 1 diamond set, rupees 2 lakhs, and 50 pair of gold. he is not stated before me and in the affair that the deceased complained before him about her apprehension of torture upon her by her in-laws and husband on non-fulfillment of further demand of dowry by visiting Titlagarh. But the witness volunteered that when the deceased visited Titlagarh, she complained before him that there was torture upon on demand of dowry. It is also a fact that PW6 has stated before me that reaching at Jharsuguda on the date of occurrence, he met Kanta Devi and talked with her. It is not a fact that on the date of occurrence we informed the informant that accused Bimala was in police station. This is so far as PW6 is concerned, but PW21 has said that it has neither stated in the affair nor in the 161 statement, but my lord is correct because it was not confronted to the PW6.
Why? I am telling you, what is the position of law?
That is the position.
Because Indian Evidence Act doesn't start thinking a person.
It will be confronted to the eyewitness first, thereafter it will be confronted to the eyewitness.
And moreover, whether a person has stated or not, only two bases are there to test it.
My lord.
One is the case diary maintained under section 172 of the CIPC,
yes.
And other the statement recorded under section 161, and its purpose is in section 162, why it is recorded. So someone is deviating from the statement, makes the subsequent response of contradiction. When someone is stating something in between the two statements, it was not stated to the police officer, but he can state to the trial. It is not completely prohibited that his statement must be confined to 161. He can state some more things. Then the court has to weigh whether this material to be accepted, what is the nature of the material. If these are the very minor material connecting the narration, then it can be accepted by the court. And those will not be the omission. Omission will be introducing a new material and which has completely changing the complexion of his statement or going against the defense, then it should be, though it's an omission, it should be treated as contradiction. That is the rule says that when commission becomes contradiction. And so the police is concerned, under section 172, he's maintained the case diary and that should be paginated and continuous case diary will be there. So there is no infraction or unfairness in the investigation. Suppose a police officer, we are living in a society which is fraught with corruption. Is police officer someone influenced without any consideration even? He says certain thing completely coming to the trial at the last phase when all the evidences are recorded and closed. He says, no, this person has stated to me such and such thing. Whether the court should believe this kind of a statement unless the court finds there is a continuity, the statement. Otherwise, IO is a person who records everything after the occurrence is over. Right?
But here, while advocating the appeal,
that is, I'm saying in all fairness, you must say
yes, Lord,
that evidence to the extent that I was also stating before the trial that they did not tell me.
Correct.
Right?
Correct.
That much is IO's role. Whether he has, the witnesses have narrated the story in a particular manner or not. I will say no. Matter ends there when he said no. So he has a different version. So what is the different version? I also can be contested, show you case diary, in which date you recorded the statement, how much time you, everything can be asked to him. All right, these are okay. I has not stated, but
even if not,
no, my question is somewhere else. I am telling you.
Malad, I got the point.
Someone is not accepting a particular statement that I have not made it or I have made it. You have to put first on his statement. Because I has merely recorded his statement. He is the generator of the statement. Though it's not a signed statement.
Correct.
Like 164 statement.
But one thing, Malad, while advocating the appeal, even if you admitted case is that some portion of evidence is left out, even if it is not confronted, my humble submission would be, if it is on record, while adjudicating the appeal, we can see that, yes, this material, even if it is not confronted to the accused, it can be considered as evidence.
Are you
Since-
sure?
But
Are you sure of the statement? I'm sorry, this is not the position of law.
But since
No, I'm telling you why. Since 1959, Tahsildar Singh's case onwards, this matter law is very consistent. How to record the contradiction or omission? Because it is the right of the person. Police is stating on my behalf what is available in 161. Police says, he said, stated to me, I have written it, signature is not there. The police officer is actually a role of a scribe.
Yeah, that's right. That's
right. The scribe can say
yes
that yes, he stated to me, he has not stated to me, but doesn't actually consolidate it into evidence. The main person is the witness himself. Whether he have stated, he may say, yes, I have stated. Police has not recorded, that can be the allegation against. You can ask the IO that whether he has stated, he said, no, stated. Then court cannot accept that statement because of this filtering, that someone is not coming to the court improvising his statement. This is the only filter available in the procedural court. That is why it is given so much of importance. At least we are in search of truth. Someone is coming into the court, there is a grudge in mind, and I will take so many, this false statement before a particular person who is being tried. This person has also get the right to get the fair trial, and this is the part of fair trial. So these things are actually very seriously taken into consideration, that whether you have shown this witness or not. Because fair trial doesn't always mean the fair trial towards the accused person, also to the prosecution also.
I'll address on that point, because since we have been appealed.
No, because I'm telling you.
Yes, my lord. I am
submitting.
I can't, once it has not been completed, I can't improve in my case. That's right. But so far as my anxiety is concerned, even if this is admitted evidence is available on record, even if it is not confronted, this part of evidence we can, at the time of adjudication of appeal, the court can look into.
This is your submission.
Yes.
So we'll look into, yes, there is a statement.
Yes.
But court will immediately form that this is not evidence. It's all right.
I'll continue that.
It's already 4:35. Okay, we'll continue tomorrow. Yes, finish it. We'll continue tomorrow. We'll grant you only 15 minutes time tomorrow. You have covered all the factual aspect, only legal position. Also, that part also you have considered.
Yes.
304B is concerned, 302 is concerned. You have made the ultimate statement at the beginning. So the other parts, so what evidence is concerned, you take and Mr. Mishra, you'll take how many? 10 minutes time.
10 minutes, because my friend is to argue for
because we'll give you the 10 minutes and give him also 10 minutes, 20 minutes.
after his statement, because I have to supplement what he want to say, Marad. I'm the informant, Marad.
No, because we'll permit you to submit, but we'll not give you the precedent. He will just submit, and you sit behind next to him and give him the inputs. Let him continue that way.
It will take 10 minutes, in fact. I'll just show the saline features and
difficulty.
on the subject.
Keep it on the file. 3:30. Only thing regarding the nature of death, this is the the important issue that you just all address on that aspect of the matter.